I think we'll go ahead and get this meeting started. So if the committee members would come on up. We'll start with any announcements or the approval of minutes of the September 10th, 2021 meeting. Are there any changes and corrections? If not, all those, I guess they stand approved. Oh, and I'll need a motion to approve them, sorry. Senator Fausto and Representative Wagner is the second. Thank you, everybody. I'm trying to streamline everything. I don't know if you guys understand. I know. All right, that's two. We have a motion and a second. All those in favor?
Aye.
Motion approved, minutes approved. We also need to figure out what day we all want to meet in the beginning of January before we lose people. Does anyone have an issue with the Friday before session starts? 10:30. You don't want to do it on Friday the 7th? What's going on? John, could you elucidate it? Okay. All right. Would you tell me when staff will be here? And we'll try to figure out if that's a good day.
Madam Chair,
Yes,
what day did the session start?
10th. Monday the 10th.
Monday the 10th. Thank you.
You're welcome. Is there a problem with anyone on Wednesday, January the 5th? Yes, Representative Wagner.
Madam Chairman, what would be the alternative dates if we didn't do it that date? It would be earlier in January?
Yes.
I mean, that's the only other options. Okay. No.
Yes. Senator Tyson.
Thank you, Madam Chair. Is there any way we could do it on the 10th when we're actually here, or would that be too late?
No, that's too late, apparently.
Okay.
That just means we all have to come back a little bit early. I'm sorry. Okay. Any problem? All right, then I would say that we'll set the meeting date of January 5th, Wednesday, January 5th at 10:30 a.m. Will it be in this room? John? Will we be able to have it in this room? Okay. All right. Thank you, everyone. Let's get this party started, and we will start with Kenny Titus from the Department of Agriculture, Division of Water Resources. Thank you for being here, Mr. Titus.
Thank you, Madam Chair, members of the committee. My name is Kenny Titus, Chief Counsel for the Kansas Department of Agriculture, and we have before you today KAR 5-19-1 through 5-19-5. By way of general introduction, these regulations are meant to facilitate the process of forming local enhanced management areas. That is a area that was created by statute in 2012, and the idea was to allow groundwater management districts, which cover the Ogallala Aquifer in the western half of the state, allow them to come up with a locally derived plan to help reduce water use and address several other criteria in their areas, but primarily the goal is to address declines in water label and water tables and reduce water use. Since this statute came into place, we have 3 areas that have established LEMAs, as we call them for the shorthand. We have 2 in northwest Kansas and 1 that just began this year in Wichita County. There is another one that is under development for the rest of GMD 1 in west central Kansas. So We've seen a fair amount of success for these, and these regulations sort of codify everything we've learned in the LEMA process. The statute itself has quite a bit of procedure in it already, but these are all the things we found helpful over the last 8 or 9 years in developing these, and we were ready to bring these forward. So the committee is ready. I can start with 519.1.
I think we are. Thank you very much. You go ahead.
So 519.1 is just a set of definitions for this, for these next 3 regulations, if there are any questions about those.
Questions? The only question I have is, this authorizes more LEMAs? You didn't have the authorization for this?
No, so the statute itself is robust enough that we were able to create these without the additional regulations. But this just sort of outlines the process that we've sort of developed over the years to make it clear what the expectations are before we start the process, how you develop a plan, and then what the public hearings would look like.
Okay. Well, I know of the LEMA in Northwest Kansas, and it's been wildly successful. So I'm glad you're doing this. You may go on.
So 519-2 outlines what we would expect from a specific management plan when it's brought forward. These plans, like I said, are primarily developed by local boards with local producers, and before they bring them to the chief engineer for review, this is sort of an outline. These are all the things we found going through public hearing process, including one judicial review case that successfully defended the authority of the statute. These are all the pieces of information we need to make sure that the public is adequately involved, to make sure that enough research has been done that the problem exists, that goals are going to be defined, and to get as much of that out on the front end so that we don't use up resources or come up short in an administrative hearing. And I would be happy to answer any specific questions about the things in the specific requirements.
Are there any questions or comments? If not, you may go ahead.
Okay. 519.3 deals with the various public hearings that can be held. So the LEMA statute in and of itself requires a minimum of 2 hearings before a LEMA could be established. And this walks through everything, the rights and responsibilities of appointing a hearing officer, the various procedure that would be used. I would note we've set this up. The important thing is to allow the public to speak as much as possible, depending on if there would be opposition. The amount of how much it looks like an actual trial can vary. And we've also added a process. So the Sheridan 6th LEMA, which was the very first LEMA in 2013, they're now getting ready for their 3rd renewal. Producers have decided to do these as sort of 5-year plans that expire and then they redo them. And so we've also added a procedure that in an area where we have an existing LEMA, people want to renew it without any significant changes, and the local board is okay with it, we have allowed sort of a consolidated hearing process so we don't have to make 2 trips out to an area and hold 2 hearings and hire 2 court reporters and try to facilitate that where there isn't any known issues.
Okay, well, I'd hate you to have to come out to Western Kansas and spend some money. That's just really awful. Okay, you may continue.
519.4, it's a requirement that due consideration for past voluntary water conservation be given. This is a requirement in the statute. This is a little bit non-specific because we want local groups to figure out how this fits best. But the idea would be that if you would voluntarily use less water in a period leading up to establishing a LEMA, typically when we say we want to reduce use by X amount, that's based on an immediately prior year period of usage. So if you were starting a LEMA this year, we'd say, well, what was your past use between 2012 and 2020? And then you have to take a cut off that use, or the basis would be on that if an area is doing that. And the idea of this requirement is that if somebody was voluntarily using less water, they shouldn't get an additional cut if they were already saving. And this just ensures that this will be adequately looked at and gives the local districts the flexibility to see how that might fit best in their area, because these plans aren't one size fits all.
Okay. right, are there any questions?
All right. 519.5 then sets forth the procedures for a formal review of a LEMA towards the end of its term. That's required by statute. And then it also, if a GMD were to put one of these in place and later decide that they needed a mechanism to change it, it sets forth a hearing process so that an existing plan could be amended. The current statute doesn't have any details on how to do that. So we've essentially put it in to the same hearing process, and that a GMD would get a veto over anything they didn't like. So it's still a locally controlled plan, requires a public hearing, and perhaps this would allow, if a LEMA didn't expire after they wanted it to last more than 5 years, there's a process to change it without having to create a new LEMA. So.
All right. Does everyone understand how much Alima has done for our water table out in western Kansas?
Madam Chair.
Yes, Representative Keegan.
Thank you. I'd like to say I think these are just common sense rules and regs, and I think they're terrific. Local control and communication with LEMA is very, very important, and I want to commend you on the job that you have done. And I certainly, as one person, understand how much they've done and would hope maybe we can get some more. So we're on a good pathway, and I want to say thank you. Thank you, Madam Chair.
Yes, thank you, Representative. I totally agree with you. So good work. Are there any other questions or comments from the committee? If not, thank you so much for being here. We appreciate you taking the time. Where did I put my colored note? Just give me one more. Thank you. All right, next we're going to have the Kansas Department of Environment via WebEx, Eugene Luger, Farah Ahmed, Ryan Vasquez. Am I missing anyone? Do we have the Kansas Department of Health and Environment on WebEx right now?
Yes, I am on WebEx. Eugene Leager, Associate Chief Counsel.
Welcome, Mr. Leager. I'm sorry I mispronounced your name.
Oh, no problem.
Okay. You may proceed with your regulations.
All right. Thank you, Madam Chair and members of the Joint Committee. As I said, my name is Eugene Leager. I'm the Associate Chief Counsel for the Kansas Department of Health and Environment. I'm here today to present the proposed regulations for contact tracing required for COVID-19. And these regulations are required to implement contact tracing for COVID-19 as provided by Section 38 of Senate Bill 159 that was passed during the 2021 legislative session. Section 38 of Senate Bill 159 required the Department of Health and Environment to draft regulations in 4 different areas. One is the qualifications and training for contact tracers. The second is the form of the oath that contact tracers must take before collecting any contact data. The third is the contact data that may be collected. And the fourth is the conditions for destruction of contact data. Now, these regulations are the same as, with the exception of a few minor changes that the Office of the Attorney General recommended, as were promulgated last year under House Bill 2016 that was passed during the 2020 special legislative session. So I guess with that, I'm prepared to go through each of those specific regulations that are in front of you.
If you can do so briefly, we would love to have you do that, so you can pause between each one so that the committee can make comments or questions. Thank you, sir.
Thank you. The first is 28-1-40. This is the definition section. It includes definitions, I think 4 different definitions that are used in the regulations. The only change that was made to these regulations is the elimination of subsection, it's currently B4, which the Office of the Attorney General recommended to be removed as they didn't believe it was necessary because the other three definitions of a third party covered everything that was necessary.
Thank you.
Yes, Senator Tyson.
Thank you, Madam Chair. I'm curious as to why the department feels that they need to extend these rules and regs. And I can wait until the section that gets back to the date extension, but overall, why are they even proposing these regulations continue?
Thank you, Senator Tyson. Because they were required under Section 38 of Senate Bill 159, these regulations specify what contact data can be collected. So it limits the contact data, the contact collectors' ability to contact, what data they actually can collect and what they have to do with that data once they collect it. So it's actually I don't say limitation, but it specifies the specific information that can be collected, and therefore whatever else is not indicated cannot be collected. It also required us to have an oath. So if there is anything, any contact data collected, they are required to take an oath before. And that was set forth in the requirements of the Senate bill.
Senator, did you have an extra question to ask?
Thank you, Madam Chair. I'm pulling up the bill now. I don't see anything that in the bill would require contact tracing. It allowed for, but not require or mandate.
I'm sorry, Senator, you're correct in that it's not required that contact tracing be done, but if contact tracing is going to be accomplished or going to be done, then there are some requirements that we are required to set forth in these regulations.
Madam Chair.
Absolutely.
Thank you, Madam Chair. So you didn't answer my original question, was why the extension on these? They sunset May 1st of this year, and now you're extending it to an extremely questionable date, January 22nd of 2022, or June 22nd of 2022. Why the extension?
The original regulations were promulgated under House Bill 2016 of the 2020 special legislative session, and that expired on May 1st of 2021. Senate Bill 159 was promulgated during this last legislative session. And in essence, it was the same requirements that were required under House Bill 2016. But because House Bill 2016, that specific section had expired, then if we were going to continue contact tracing for COVID-19, we were required to promulgate regulations for House Bill or Senate Bill 159.
Thank you, Madam Chair. I'm looking at the bills. It's not what I don't think that's the intent, is to continue the contact tracing, but I'll look forward as we continue on the rules and regs. Thank you, Madam Chair.
Absolutely. Senator Warren, you had a question or comment?
Yes, thank you, Madam Chair, and thank you for being in committee today, Mr. Lugar. I had a question regarding the COVID-19 contact tracers. Is this regulation that we're looking at, 28140, is that specific to COVID-19 contact tracers?
Yes, it only applies to COVID-19 contact tracers.
Because we also have contact tracers for other
This is only COVID.
health concerns, correct?
Yes, contact tracing's been, I mean, going on for many years, and it's been done for different various infectious and contagious diseases, but these are only specific to COVID-19.
Right. And could you tell me how many, if we're looking at section, I guess, B of the regulation, new B, how many COVID-19 contact tracers do we currently have in Kansas?
I'm not sure, but Farah Ahmed, our state epidemiologist, is also present. So I don't know if she can answer that question or not.
She's muted, but if the chair has granted her
Yes.
the floor, then I'd
Yes.
appreciate an answer.
Yes, if you would, can you, the epidemiologist, would you please illuminate everything that we need to know?
Good morning. Can you hear me okay now?
Yes, ma'am.
Okay, great. Thank you so much, Madam Chair. So to your question, we currently have 126 contact monitors. The highest amount that we probably had was about 150, and the smallest was probably around 20. So that staffing number really depends on case counts and what the local health departments are sending to KDHE to be monitored.
And Madam Chair, if I
Yes,
might.
absolutely.
I see that's in the next regulation that we're looking at that we're not yet talking about. So I will reserve my next question till we get to that. Thank you.
All right, thank you, Senator Warren. Right now, Mr. Leaguer, you can continue.
All right, thank you. The next regulation, 28-1-41, addresses contact tracers, the qualifications and training for those contact tracers, as well as the required oath that they're required to take. There were no changes to this regulation from last year other than the authorizing statute.
Senator Tyson.
So this is going to get in the weeds, Madam Chair, but the authorizing statute that you are referring to is a conference committee report. It was not Senate Bill 159. And I'm reading the language, it does not say contact tracing, it says contract tracing.
I'll let you go ahead and look that up and see, sir.
I guess the version I have in front of me, Section 38 of that Senate bill, specifically is an appropriations bill that requires the department to promulgate the regulations.
And if I may, Madam Chair, I'm looking at the summary from legislative research. So maybe it was a typo from research, but the conference committee report has the language in it, but right, I've got that. But that bill did not pass. It was a conference committee report that became law.
Did you have another question, Senator? I think at this point, I would like to ask, why is it necessary you have contact tracing for many other issues, any other, like measles or smallpox, or why are we making separate rules and regs? Why aren't we doing one for which when you're doing contract tracing, why are we just adding more regulations and rules to confuse people? And it doesn't make any sense to me because it doesn't, I think the senator's right. It doesn't say you have to do this for contact tracers, because it's just giving you a general, do some rules and regulations. So saying you're being forced to do this by the statutes and the legislation doesn't sound right.
Well, the bill actually, it states that, like, for instance, that persons acting as contact tracers under the authority of this subsection shall meet the qualifications and training prescribed by rules and regulations prescribed by the Secretary of Health and Environment. So we thought to implement and to allow contact tracers, if we are going to conduct contact tracing, we have to have some kind of regulations that specify what the training and qualifications of those contact tracers are. Without that, I think then that could be open to anyone basically becoming a contact tracer. So we felt like under the specific mandate or requirements of that, we needed to specify what their qualifications and training were.
Senator Tyson, I keep turning myself off.
That's
Sorry.
fine. Thank you, Madam Chair. I appreciate it. And so maybe the suggestion would be, since we are going to have a special session, that we include legislation that would stop the specific contact tracing.
Madam Chair.
Yes. I can't see who's asking me. So
Annie Keith.
Annie Kiefer. Representative
thank you.
Kiefer.
Thank you, Madam Chair. I think the intent for this is to follow the language in the bill, and it's just renewal language, and with a different date. The pandemic is not over, and to have specific numbers and information concerning COVID-19 helps all of us to understand what is going on, and it continues to go on. So we're not out of the woods yet. And so for this to go until a date certain in 22 doesn't bother me at all, because we certainly are not out of the woods. COVID-19 is still right there with us in the room with all of you, and I'm here in my house. You know, I think we're barking up the wrong tree here, and I certainly think these reaffirmations of these rules and regs make sense to me. Thank you, Madam Chair.
Thank you, Representative. Senator Warren. I'm sorry, then I have to do Senator Vascudo.
Thank you, Madam Chair, and I appreciate the opportunity to appear via WebEx due to schedule conflicts that I have in the area rather than the travel time. I appreciate it. Had some obligations that came up that I wasn't aware of before this morning, so appreciate that. That's the reason I'm not present in the committee meeting room. And Mr. Lugar, 28-141, what we are not looking at as proposed changes, 28-141 was first approved because of the House Bill 2016. I think that came out of special session in 2020. Is that where these originally came from?
Yes, the special session, 2020 special legislative session, and House Bill 2016, these came out of that bill.
To follow up on the chair's question about the difference in these regulations regarding contact tracing for COVID-19 versus contact tracing for measles and mumps and other things like that, just generally, what is the difference? Are we being more protective of privacy with these COVID-19 specific contact tracing rules? Or what's the purpose other than, as you had said, to comply with what was in the Senate Bill 159, Section 38? Is there some other purpose, such as, again, to be more protective of individual privacy for the people who are having their information submitted because they're being traced by the contact tracers?
Thank
James,
you.
you want me to-
Okay, thank you for the question, but currently we don't have specific regulations for contact tracers. There are a statute 65-118 that limits the release of information and makes the information that is collected confidential. But these regulations that specifically apply to COVID-19 really are more restrictive to make sure that the information, there's only specific information collected. The information collected is confidential, and then once the information is no longer necessary, that it's destroyed. So, and Farah I don't know if you have any other additions to that.
I do, Madam Chair, if I might. I would say that the difference with this set of regulations specific to COVID versus any other disease is, I think, that it also puts bumpers around who can be a quote unquote contact tracer, with the stating that they have to have they have to be a certain age, they have to have a certain background, and they have to take that oath. And that's the more restrictive piece.
Thank you. And one last question, if I may, Madam Chair.
Yes, of course, Senator.
Thank you. We now have, I think, Ms. Ahmed, you said we have 126 contact tracers for COVID-19. Could you tell folks following online and the committee, where do these 126 contact tracers, where are they? Do they sit at KDHE? Do they sit at home? Are they around the state? Are they concentrated in more populated areas? Kind of tell us a little bit about the 126.
Sure. So if I might, I maybe take a small step back, because the term contact tracer, I just want to make sure everyone is kind of understands what we're talking about. So when a case is identified, so somebody tests positive, they're going to hear from a case investigator. So that's either someone who works for the local health department, or they're going to hear from a KDHE contracted case investigator. So we have about 52 people right now that do that, and that's a contract with a company called Insight Global, and also a company called Accenture. So they're not physically located in Topeka, physically located at KDHE. They are contract employees. So then they talk to the case, and they'll ask them about who they might have exposed while they were infectious. And then the people that they identify are the close contacts. So then those close contacts are notified by either a local health department person or a KDHE contracted contact monitor or contact tracer, and that's through a company, Accenture. So, that contact monitor is going to let them know you were potentially exposed on this day, your quarantine period looks like this is when you can get out of quarantine. And the other thing that they're going to do is that they're going to offer the person an optional monitoring. So it's completely optional. But just, it's essentially, we can call you, or we can text message you every few days, check up on you, see if you're okay, see if any symptoms have developed, help figure out where you can get tested if you do, want to get tested. So that's what the contact monitors are doing, also checking to see if they have everything they need while they're staying at home.
Senator, does that answer your question?
Sorry, I was muted. It brings up one short follow-up. When you say make sure that they have everything they need while they're staying at home, does that mean taxpayers are paying for food and other things? What does that mean?
So for a while there, we had federal money that came to us that the local health departments could apply for, and specifically have like essentially like case managers. So if someone said, for example, you know, I need to get my medication and I don't have anyone that can run and pick it up for me. So some counties were able to, with this federal money, hire people that would help arrange that or help arrange to get their groceries, that kind of thing.
Thank you for those answers, and thank you, Madam Chair.
All right. Senator Fausto.
Thank you, Madam Chair. So, two questions. And since we're already talking about it, KAR 28142, so the information that is the data that is gathered from the contract tracer, is that information collected in person? Is that information written down? I know you said eventually it would be deleted at some point, but the initial gathering of that information. So can you just speak to that again? How is that? So is it an email? Is it through any type of public venue to whereas anyone else could get that information?
Yes, ma'am, I can answer that question. So we use an application called Salesforce, and so all of the scripts and everything is built into there. So if I'm monitoring you and you agree to be monitored, yeah, go ahead and give me a call. It's a phone call initially, and say you opt in to hear from me every other day, then, you know, I'll talk to you, make sure everything's going okay. I'll note it down in the system. Once your quarantine period is over, that record is completely done and closed out, and the contact monitor doesn't have access to it anymore. It's gone.
Okay, and thank you for that. And Madam Chair, I actually have a question for the Senator Karen Tyson. You mentioned that you might propose legislation during the special session to address your concern. Is that an amendment on the bills, the other bills that we will be dealing with during the special session, or would that be a standalone bill? Thank you, Madam Chair.
Yes, please, would you answer that?
Thank you, Madam Chair, and thank you for the question. I am not driving the ship for special session, so I can't answer that, but I did reach out to leadership and let them know. I don't think a majority of legislators, however, the representative that spoke for contact tracing actually voted no on the bill that it was in. I don't think a majority of legislators knew that that was in a budget bill. And so I hope that we can add that to include and be included in the language that I have many constituents, as I know as you guys do, that are extremely concerned about privacy these days and government overreach, especially with what the federal government's trying to do with our bank accounts and other items. And so this just seems aggressive, especially 126 employees still doing the contact tracing. And I also was looking at Salesforce. I would be curious as to whether that went out for bid or was it sole source? How did they land on that software to manage contact tracing for health? It's a business application for sales. So thank you, Madam Chair.
I can answer that question about
Yes, please.
how we landed on Salesforce, Madam Chair, if you'd like.
Yes, please.
So you have to kind of think back to the beginning of the pandemic, which is, you know, a good year and a half ago. So Salesforce had developed an application specific to contact monitoring, and the state of Massachusetts has been using it. And so at that time, we talked to the state of Massachusetts Health Department, we talked to Salesforce, and decided that it would work for us, and that is how we went with that application.
Yes, ma'am. You may go ahead.
Thank you, Madam Chair. Could the committee get from research the contract so that we could see what was, what contract the state has with Salesforce? Thank you, Madam Chair.
Thank you. I think you all can do that, please. All right. Representative Sutton?
Thank you, Madam Chair. I didn't have any real questions until we got into the discussion a little bit. Now, all of a sudden, I find that I do. First off, I think I'm probably comforted a little bit by the fact that we've set some parameters for who may or may not be a contract tracer with regards to COVID-19. But does that then necessarily lead to the fact that contact tracers for any other disease have no qualifications whatsoever?
Madam Chair, I can address that.
Yes,
So-
please.
So the way that contact tracing is, as a public health tool has traditionally worked is you've got your public health nurses at the local health department who are talking to cases and identifying close contacts, susceptible close contacts for a measles case, for example. And they're the ones that have generally followed cases and contacts, and that infrastructure worked great until COVID hit. And now you all of a sudden have thousands of people who are considered susceptible close contacts because you have a large number of people that didn't have this, they didn't have disease, so they don't have a natural immunity, and we didn't have a vaccine for a long time, so you don't have a vaccine immunity. So one person with COVID had the potential to expose a lot of people, and you have a disease that has a lot of close contacts versus something like a measles where most people are immune, so you have very few susceptible close contacts. So that expansion of the number of people that had to be brought on to do contact monitoring for COVID, I think is the reason why bumpers were put around who that workforce could be.
Senator, does that answer your question? Or, I'm sorry, Representative.
It doesn't, don't demote me like that. Not entirely, but I think the majority of this conversation can take place elsewhere. I do want to go into a slightly different vein. We were talking about where did we get Salesforce? How was that determined? I kind of have the same question regarding Accenture. How were they awarded that contract? Are they within the state? Are we employing Kansans with this, or are we shipping more money out of state?
They're a contractor workforce. They're not necessarily in Kansas, no.
All right. How did we come upon Accenture as the person to win this contract?
I would need to look back on that. I don't believe that it actually went out to contract.
I don't believe that either. That's kind of my point.
So I think we would need to look back at the history of that. I believe when we had emergency authorization that we were able to bring on contracts without going out for bid.
Always a lovely practice. All right. Thank you, Madam Chair.
You're welcome. I believe we have Representative Nguyen.
Thank you, Madam Chair, and I look forward to unraveling this onion and a lot of onions. But on 28-142, what I would want and suggest the senator and other senators and representatives whose constituents are concerned, it says participation in COVID-19 contact tracing is voluntary. So if they don't want to participate, if they're concerned about the issues you noted, then they don't participate. Now, that takes care of that issue, but of course, we're here for a larger issue. So again, I look forward to unraveling a lot of onions as we go into our next session. Thank you.
Senator, did you have something else? I guess it was Senator Warren who had a comment.
Madam Chair. I look forward to unraveling this as well regarding the budget for Accenture, and I think you mentioned Insight Global as well. And then also, is KDHE measuring the impact of the contact tracing on, I mean, what's the benefit of it? I understand the stated intended benefit. Is it actually helping? And then you had mentioned that for other diseases like measles, contact tracing isn't as impactful or needed because of immunity in communities and all. And are we approaching that? That's a whole different discussion. Are we approaching that with COVID-19? But something to keep in mind, I think, as we fluctuate. I think you said between 20 contact tracers and as many as 150. So, was the work not getting done with 20? I think you said it bounced up. So just a lot of questions and concerns about how this is being implemented and what it looks like going forward. Even when it started with the awarding of the contract, and a lot to unravel here. So looking forward to continuing to do that. Thank you, Madam Chair.
Madam Chair.
Yes, Senator Voskado.
Thank you, Madam Chair. If the individual is still on with KDHE, so when we talk about the 120 or the 52 or the emergency needed because of the deadly disease COVID, so can she explain the difference, or is it similar to if there is an individual with an STD and they go to the health department, they are positive, surely they ask who have you, who have your partners been with lately, or who have you been with lately? And so then those individuals are contacted to be alerted that they might need to go get checked. So can you explain that difference or similarity of that issue? Thank you, Madam Chair.
Yes, ma'am. So it's generally the same concept for infectious diseases, contagious diseases across the board. So when someone is identified as a case of whatever disease because of a positive lab report or, whatever, then someone is going to talk to them and try to identify who all they would have infected. Now, the question of susceptible close contacts, that's the who all they might have infected that could actually get the disease. That's the thing to distinguish, because again, if you expose someone, but that person is considered immune because they had the disease or they're vaccinated, then it's not really a problem, right? So we're not talking about quarantine if you're immune. So it is the same concept of identifying those susceptible close contacts, letting those people know that they were potentially exposed so that they can make a decision about, okay, I'm going to go ahead and quarantine myself away from other people. Okay, I'm going to make sure I get tested. Okay, I'm going to pay a little bit more attention to the symptoms. So maybe I would normally write something off as my normal allergies, but now I know I'm exposed, so I might think about going to get tested. So it is the same concept.
Question answered. Okay. I have to tell you, I'm still looping back to, if you're always going to need contact tracers, you may just have to make contact tracer regulations instead of making this purely for COVID. With COVID changing, it's a virus, just like the flu. It's not going away. We'll have it forever. Thank you, unnamed country. So I have a problem with this being just specific here. We need to make sure that if we're doing this and we're making the rules for contact tracing, we should have something standardized for any kind of disease or virus. And so I have a problem with this altogether because I think it's very short-sighted. Did you want to move on, Mr. Leaguer?
Thank you, Madam Chair. We've already discussed it, I guess, in some detail, but the next regulation 28-1-42 talks about what contact data may be collected, includes the personal information that may be collected and the health data that may be collected. It also indicates that the contact tracer or the contact is not compelled to participate in or is not prohibited from participating in contact tracing.
All right. Questions, comments? Representative Sutton.
Just, thank you, Madam Chair. I just don't want to put too fine of a point on this, but the data that the contact tracer receives prior to contacting the person who has been infected or allegedly has been infected, does the person infected give permission to then do contact tracing, or is that person given private medical information about someone without their consent?
Madam Chair, this is Farah Ahmed. I can probably answer that for you, if I may.
Yes, absolutely.
So the way that it works is when a case investigator is talking to a case, and they kind of walk them through the timeline of when they were infectious and when they would have potentially exposed a person. So it's up to the case to tell public health, okay, I think I might have exposed this person, this person, this person, or, okay, I went to work on this day while I was infectious. So it's up to the case to identify. Then when we go to talk to the person who was actually potentially exposed, all they are told is, you were potentially exposed on this day. They don't know who. They're not given any information. Just, you were potentially exposed on this day, which means your quarantine period is this long. This are the signs and symptoms you should look out for.
All right, so okay, that actually leads to two questions. First off, when the case manager speaks to the person infected initially, who has initiated that contact?
The way that we find out somebody is a case is all initiated through a person going to get tested, and that test result comes to KDHE. And then depending on if a local health department is doing their own case investigations, then they'll hear from a local health department public health person. If KDHE is doing it on their behalf, they'll hear from a KDHE case investigator.
Who may very well be a person out of state who suddenly now has their medical information.
They have very limited medical information. Yes, they do know that that person is a case, and their job is to figure out who they might have exposed.
All right, thank you. Thank you, Madam Chair.
Yes. All right. I'm sorry, Senator Tyson.
Thank you for the testimony. I have concern about the data actually being in a database such as Salesforce, also medical information. But when you are contacting, or when a tracer is contacting a person that is a known case, do they explicitly state that there is no obligation for that person to answer these questions?
Madam Chair, I can answer that as well.
Please do.
You are correct. A case does not, they're not compelled to tell us who they potentially exposed, just like a contact is not compelled to be monitored.
I asked if they are told that on the call, though, because I have constituents who have been contacted and they were not aware that they did not have to. They thought, since it was an official authority calling them on behalf of the state of Kansas, that they were compelled to opt. They were never told that they did not have to answer those questions.
I do know in the script that KDHE has, if KDHE is the one calling, it does say, so participation is voluntary. It's in the script.
So what script are the other callers using, if not the KDHE script?
So if a local health department is investigating their own cases, they are not necessarily following the script from KDHE.
I think, or I believe Senator Tyson was asking more about the contract tracers, if I'm saying it all correctly.
If KDHE is doing the contact monitoring, then they should hear the word, "You are not obligated to participate."
Yes, ma'am.
Thank you, Madam Chair. So are you telling me that all of the county health officials have access to the Salesforce system also?
They do if they choose to use it. They don't have to. They can have. They don't have to, but they do have access to it. Yes.
Thank you, Madam Chair. All right.
Is there, let's see, where are we? Gotten in the weeds. We need to Representative Sutton.
Thank you, Madam Chair, and I realize this is for a second time. I won't continue to beat on this. But one thing that you said took a couple of minutes to sink in, so I think slowly sometimes. You mentioned that when the contact tracer contacts someone who has potentially been exposed, they say what date that was, and then did you say the word quarantine?
Yes, sir.
But the person hasn't been tested. The person isn't necessarily sick. Who's issuing a quarantine to healthy individuals?
So there are two concepts here. If someone is known to be a case, so you've tested positive, you have an isolation period. So your isolation period covers the time period where you could potentially infect other people. If you've been exposed, so you're not a case yet. If you've been exposed, you have a quarantine period, and the quarantine period covers the amount of time your body can develop virus, essentially. So it's two different concepts. So there are isolation, there's an isolation period, and there's a quarantine period for people who are exposed but not sick yet. So to your specific question, depending on what the county local health officer has decided for that county, and essentially the Board of Health for that county, either quarantine will be recommendation, so it'll be your recommended quarantine period is from this date to this date, or some counties actually issue written quarantine orders.
Do you, off the top of your head, know which counties those are?
I do not off the top of my head.
At some point, I'd like to get that information. I understand that it's kind of out of the blue today. That's not a problem. Thank you, Madam Chair.
Senator Warren, you have another question.
Yes, thank you, Madam Chair. And I know we're trying to move on, but I just want to state regarding that last comment, I don't see the difference between an isolation and a quarantine. If you're, ordered to isolate, you're ordered to quarantine, or you're acting under county authority to do those things, to the person that affects, it seems to me it's the same, and we're just talking semantics. So isolation for a person who is actually already tested positive versus quarantine for someone who's been exposed, in reality, that is the same. You're isolated, you're quarantined, and it has the same impact and effect. So again, part of what we need to continue to unravel in this regard, but probably not here. Thank you, Madam Chair.
Thank you, Senator. Now the only thing left is the sunset provision. Did you want to go? That we'll probably be unhappy again with, but could you please address the sunset provision?
Yes, 28-1-4 is the sunset provision. And last year under House Bill 2016, that was May 1st of 2021. This one is the sunset provision is June 30th of 2022. And the reason for that is specifically that there is that the House bill or the Senate bill 159 that applies to appropriations for the specific fiscal year, and it expires at the end of the fiscal year, which is June 30th of 2022. Therefore, the requirements within this specific Senate bill would expire, so these regulations also would expire.
Well, I sense, I think are there any other questions or comments? Senator Tyson.
Thank you, Madam Chair. He did not address the portion that added the language that the data would be collected and shall safely and securely be destroyed in a manner approved by the Secretary. Why was that language added?
I'm sorry, that's 28-1-43. Yes, you're correct. That was language I believe was recommended by the Office of the Attorney General. And because I think that mimics or reiterates what's in the Senate bill that was passed. I think they wanted to add that language safely and securely to make sure that, be specific as to that's not released or just thrown in a dumpster, I guess. So that language was added at their recommendation.
If I may.
Yes, Senator Tyson.
Thank you, Madam Chairman. So the process has to be approved by the Secretary. So we already know that the department would be held responsible if there was a data breach. So are we just making it clear that it's the Secretary's responsibility?
Sir?
Yes, that requirement is specifically that it is the Secretary that determines how that information is to be safely and securely destroyed.
Thank you, Madam Chair.
Senator Warren, I believe you have another question.
Thank you, Madam Chair. To be clear, Senate Bill 159 isn't where this originates from, because I believe Senate Bill 159 did not pass both chambers. And as we've heard, the requirement section 38 that created what we're looking at today was in a conference committee bill in it was appropriations, I think, and Ways and Means, I think, if I'm correct. But it wasn't Senate Bill 159, but the reviser can correct me if I have misstated that. But in any event, I wanted to get to, Madam Chair, if we are going to be looking at the economic impact statement, or should I wait and hold questions about that in a minute?
I would say, Senator, you might as well go ahead.
Okay, thank you. On page 2 of the economic impact statement, it's section F as in Frank. It asks, do the above total implementation and compliance costs exceed $3 million over any 2-year period? And the answer is no. So that helps answer some of the questions I had about what's the cost of all this to implement this contact tracing for COVID-19. So is it then true that over a 2-year period, the cost does not exceed $3 million for this contact tracing program we're doing for COVID-19?
Well, Farah, go ahead.
Madam Chair, if I might,
Absolutely.
the fiscal impact of the change, so the requirements of who can be a contact tracer, the oath, the safely and securely destroying, the fiscal impact of that is minimal. the fiscal impact of actually doing contact monitoring is not minimal.
And it would probably then exceed the $3 million over any 2-year period, correct?
Yes, ma'am.
And we don't have that information before us right now, correct?
Other than I have a dollar figure on the Salesforce application and what all that covers, but if you want something more extensive than that, we would need to dig. Yeah.
And in fact, I think on page, they're not numbered, but the last page of the economic impact statement report, it asked for, at the top, still section F as in Frank, give a detailed statement of the data and methodology used in estimating the above cost estimate. And the reply was the above cost estimate was based on the activities to implement these specific regulations. See the above. I'm just wondering, it's not, doesn't seem to me very detailed of a statement, but I would like in these economic impact statements to have full and complete answers would be my suggestion for the committee and for the department. Thank you, Madam Chair.
Yes, thank you, Senator. Did any of you at KDHE want to respond to that?
This is Farah Ahmed. If you would like additional information on the cost of contact monitoring as a public health tool, we can certainly get you a fuller picture of that.
Thank you. That would be helpful if we could, Madam Chair.
Yes, thank you very much. I think what I'm hearing from the committee is that there are a lot of questions about these rules and regs, and perhaps you should get back to us at the beginning of January before we do any kind of implementation. And maybe you can get that information to our committee by then. Since this says it will sunset, it was supposed to sunset, I lost my place, but, so it's already sunsetted, May 21st, 2021. I don't think it'll be a big problem to wait until January of 2022.
Thank you, Madam Chair.
Yes, Senator Tyson.
Thank you, Madam Chair. Since it has sunset May 1st, are they continuing to follow, are they working under the old rules and regs, or how are they operating? Because you know they didn't stop
No, you have not.
contact tracing.
Sir?
This is Farah Ahmed. We have continued to operate under the old rules and regs. So we still have in our script that it's completely voluntary. We still have the oath, the whole thing.
So if I may, ma'am.
Please.
Thank you. What is the hourly rate that we are paying Accenture for the calls, for the people to make the phone calls?
I do not know that off the top of my head, but as we get you a fuller idea of how much contact monitoring costs as a tool, we will pull that.
Okay, well, just roughly, if you have 100 employees, 40 hours a week for 40 weeks, it's over $3 million. So you definitely exceed that number. And I would also ask that you state that the border states have no regulations that are similar to this. Are they not doing contact tracing?
They do contact tracing and contact monitoring. They do not have a specific set of regulations about who can be a contact tracer, the oath, and those kind of bumpers around it.
Okay, well, I'm glad to hear that Kansas is ahead of the curve on restricting and guarding our privacy, but we need to be stronger than we already are. Thank you, Madam Chair.
Yes, is there anyone else? If the committee does not agree with me, I would like to see you come back and wait until January so we can look into this before we finish. For a January meeting. Yes, Representative Carmichael, let's get you back to the microphone.
I apologize, Madam Chair. I thought we were headed to the next regulation. I just want to make sure I'm clear what you're saying. Are you saying you want them to come back and see us in person in January to continue to discuss these regulations or some other regulation?
To bring information to us so we can have better information before they implement the rules and regs.
I'm not sure that the statute allows for that. And so I would like to request an opinion from the reviser as to whether this committee has the power to require an agency to appear more than once before the committee.
I don't believe, Representative, that I'm requiring them to. I'm asking them to. And I think that that's fair. We have a lot of questions that have to be answered.
And I appreciate the circumstance, but you know, it's always been the policy and practice of this committee to prepare our written comments and that we submit those to the agency. They're also made a part of our preliminary report as well as our final report. And I would caution that trying to require agencies to continue to come back before the committee, I don't believe we have, I don't think, as you point out, we don't have the authority to require them to come back. And realistically, if we don't have some finality respecting regulations, i.e. they present them here, they take public comment, and they adopt or don't adopt, then we lose what's called regulatory certainty, and that's a bad thing for business. Thank you, Madam Chair.
Yes, Senator Fausto.
Thank you, Madam Chair. So, question to KDHE, would this delay or our recommendations, as Representative Carmichael stated, how does it affect what you need to do for the health safety of Kansans? Madam Chair, just for clarification, so as was stated, the allowing you to do this is already sunset. So, but you're doing what you need to do anyway. How does this delay affect that, or can you still operate and notify? Thank you, Madam Chair.
Madam Chair, I think I can answer that. And Jean, just correct me if I'm wrong. We don't have any intention of rolling back the protections or the bumpers. So I believe we would just continue as we are.
Yes, we have these provide the, as you said, the bumpers. And so we would like to get them in place so that they are in regulation, that we are required to follow those requirements, those restrictions, and so that the oath is in there, the statement about you're not being compelled to provide information is in there, those things. So I guess the sooner that's put into regulation, the better.
Are there any other thoughts? Does the committee wish to have them come back and with information just to be able to visit again? Or do we want to just say thank you and let them go on their merry way, since they've been doing this since May 1st? Yes, Senator Tyson.
Thank you, Madam Chair. I think this is a prime example of why your constitutional amendment is needed, so that this committee does have the authority to impact the process once rules and regs are kicked off. I am very hopeful that we can get language to address this in the special session. Thank you, Madam Chair.
Representative Sutton.
Thank you, Madam Chair. That's kind of what I was going to say. Would I appreciate more information before these are promulgated? Absolutely. But if that's not possible, I'm pretty sure we can solve the problem legislatively. Thank you, Madam Chair.
Good. Senator Warren.
Thank you, Madam Chair. Want to echo that it's probably something we need to address. I think there's a amendment, a constitutional amendment that's been presented, and we could possibly take a look at that to address this situation in the future. We probably don't have the tools right now that we need to do that here in this committee, but the legislature could certainly take up that constitutional amendment to prevent impasses like this, if you will. But there is a way forward, and we do need certainty for the business community and for individuals in Kansas as well. And I appreciate the thorough ability we have had to ask questions here today, and I'm glad that we're putting into place more protections for individuals as regarding protecting their privacy, and just probably something we could take up legislatively, and not today. We don't have the tools for it. Thank you.
So then we do not want to bring it back up. I'm trying to get a feel for how, yes, no, where are we on this? Senator Tyson.
Thank you, Madam Chair. From what I heard from the department, they plan to disregard all of our comments today and move forward on the rules and regs. So I think they'll be implemented by our next January meeting.
Well, also due to their previous behavior of trying to get a vaccine schedule set up for school students when they sent it out to all the schools and said they were required before they even came before us. I would assume that's probably the case. So thank you very much for appearing before the committee. We're going to ask for information. I don't think we're going to ask you to come back. All right. Let's move on. I believe we have Larry Carnes here, Executive Director of the State Board of Technical Professions. I'm sure wishes he went before this last discussion.
Madam Chair, good morning.
Good morning. Thank you for being here.
Certainly. We're here today on KSA 6671.
Can you pull the microphone down, sir, so they can hear you online?
Certainly.
Thank you.
We're here today on KAR 6671, which is an amendment to our applications regulation. It deals with the materials that an applicant applying for licensure to our board by reciprocity needs to send in along with their application. We revised the regulation to comply with the terms of House Bill 2066, which was passed last year, which gave a new path for reciprocity licensing for military service members, spouses, individuals that reside in Kansas, and those that intend to reside in Kansas. Regulation basically just indicates the type of materials they need to provide the agency along with their application.
All right. Does anyone have any question or comment? Representative Carmichael.
Thank you, Madam Chair. Mr. Carnes, you might note that some people from a past life are here today. We have some of the leading work comp lawyers in the state, and I count you as one of them. I just wondered if you'd like to stay a little bit longer this afternoon so we can get 2 bites at your apple, so to speak.
I intend to hang around.
Okay. All right. I'll look forward to watching. Thank you, Madam Chair.
Senator Tyson, have you had a chance to find your?
Thank you, Madam Chair. I can't find my notes on this. I did have a question on the reciprocity, and I don't remember it off the top of my head, so I'll move on. Thank you, Madam Chair.
Okay, thank you very much. Did you want to go into any detail with anything else, sir?
Unless the committee has questions.
I'm glad to see this implemented, is the only thing I have to say. All right. Well, that was quick.
Very good. Thank you very much.
All right. Thank you for being here. We will move on to Clay Barker, General Counsel for the Secretary of State. Thank you for being here, Mr. Barker.
Thank you very much, Madam Chair and Madam Vice Chair and members of the committee. It's a pleasure to be here. I'm here today because our office is revoking 5 regulations, not appealing or amending them or replacing them, just straight out revoking. Before I start, I'd just like to take a minute and introduce my colleague, Whitney Temple, who has joined our office from Congressman LaTurner's office and is in charge of communications and policy. And you'll be seeing her a lot this special session and the regular session.
Very nice. Thank you for being here.
All right, as I said, we're revoking 5 regulations, and the common thread between all 5 is that in the 2021 session, the legislature eliminated the statutory authority for our office to regulate in these areas. So with no authorization, we have to revoke these. The first 3 have to do with publications and the cost of publications. 730-1 has to do with the cost of the session laws. And 732-2, I'm a little bit out of order, has to do with the cost of administrative regulations. 732-1 has to do with the cost of the delivery of session laws, regulations, the journal, and statutes. And we no longer have the authority to set those by regulation. We'll be setting those costs based on the cost it accrues to us. And as an example, the 2020 session law was tiny because it was cut off by COVID, but it was a fixed cost. No matter how much it really cost us, we had to charge what was in the regulation. And if you're curious, the cost of the statutes and the journals are set by the Legislative Coordinating Council. That's why they're not in these regulations. And moving on to the last 2 regulations, 735-1 and 735-2 had to do with the old census adjustment that was eliminated when the state passed the constitutional amendment in 2019. And then in the 2021 session, the legislature eliminated the statutes that had to do with that census adjustment, including the one that authorized us to issue regulations. And now this is just final cleanup, eliminating those regulations that had to do with taking the census adjustment and the questionnaire that used to be sent to the military and college students.
Any questions so far? Senator Falscadeau.
Thank you, Madam Chair. So thank you for being here today. So just for clarification for those that are listening in, just elaborate a little bit and be more specific on the publication part of this so that people aren't confused of what publication fees you're speaking to.
All right, Senator, there's a variety of organizations, mainly the Secretary of State Legislative Coordinating Council, that set the cost for government legal publications. That can be the statutes, the supplements to the statutes, the session laws, the journals for the House and Senate, and the administrative regulations and the supplements for those. And those costs can be the cost to buy one of the books or a set or the delivery costs. And those previously were often set by regulation. The Secretary of State would issue regulations on the cost. But if you have the history of those regulations, they haven't been updated in 20 or 30 years because it was difficult to update. And they often, I believe the legislature's intent in taking away our authority to issue or set costs by regulation and just set the cost by the actual cost was, in some cases, the actual cost has gone down, so we were overcharging customers. Sometimes it may have inched up a little bit over time. So we were losing money, and we're a fee-funded agency, so we need to cap what we charge customers to the actual cost to us, so we don't gain money or lose money. And this is, once the legislature set that policy in legislation, we followed through by eliminating these regulations.
Thank you. Thank you, Madam Chair.
I believe Senator Warren has a question.
Thank you, Madam Chair. And I think it's a rare instance here where we actually are having less regulation rather than more. So it's kind of interesting and a little bit welcome. And speaking of welcome, wanted to welcome Ms. Temple. 3 of the members of this committee, Senator Falscadeau, Senator McGinn, and I serve on a different committee where Mr. Barker and I believe your predecessor, Ms. Temple, came and testified very often in front of our committee. So look forward to seeing you there and seeing Mr. Barker return there as well. Thanks so much for being here today.
All right. You have more to, or did you get through all of them?
That's all I have, Madam
That's it.
Chair.
Well, I have to agree with Senator Warren that it's really refreshing to get rid of some rules and regs, and that doesn't happen very often. I'd like to see that more often, so.
We'll do our best.
Okay, all right. Well, thank you for being here. We appreciate your time.
Thank you.
All right, now at this point, I have a question. I have a feeling the next lineup is going to be fairly long. would the committee like to just forge forward? Or would you like to take a brief 45-minute lunch break? Everyone wants to move on. Okay, all right, okay, all right. Well, there we go. Now we need the Jeff King with the Department of Labor, Division of Workers' Comp. Thank you for being here, Mr. King.
Thank you, Madam Chair and committee members. We're here today with 5 proposed new and 1 amended reg in the workers' compensation arena. The first reg we're looking at is 51.320, notification of termination of benefits. Basically, what this reg requires is that the employer or insurance carrier notify an injured worker when benefits are being terminated. So if they're receiving temporary total benefits or medical benefits in Kansas, those can just be stopped without any notice to an injured worker. So injured workers need to make plans. If their benefits are terminated, they need to maybe apply for work, apply for other benefits from other sources. And this simply just requires the employer to notify them when and why the benefits were terminated.
All right, and for the benefit of the committee, I'd like to, I don't know how many people want to come up and testify about this. 4? Would the committee like to wait until everything is done and the people coming for the testimony before we ask questions, so we can maybe, is that all right? All right, I guess you may go ahead.
Okay. The second KR is 51.910. That's an amendment to that reg. Basically, what this reg does, it's another transparency, a communication issue. We would require employers, insurance carriers, or their nurse case managers to just share correspondence with injured workers. If they write the treating physician, share that communication, share the communication back from the physician. And then if they want to have oral communication with the physician, they need to get a special authorization and at least give the claimant the opportunity to participate in that discussion. And one of the biggest problems and biggest reasons for this is that an employer in Kansas gets to choose the treating physician for an injured worker. So there's sometimes a little trust issue just in that process. But once the physician is chosen, that is the worker's treating physician, and that physician is supposed to direct all medical treatment. So this just allows the injured worker to participate and be aware of any communications with his authorized physician and participate in the medical treatment, his own medical treatment. 51.9.8 is a new reg, and this is regarding a designated authorized treating physician. As I just mentioned, the statute 44.510H allows the employer to choose a treating physician for an injured worker. In looking at potential problems for this, the statute does provide that if a claimant, an injured worker, is not satisfied with treatment of that physician, they can request a change of physician. There's a process they follow. They go through the preliminary hearing statute in 44.534A and request a judge, if show good cause, why, and request the judge authorize a different physician. The statute doesn't address what the employer does if they want to change physicians, but most likely because the statute indicates that it's the employer or insurance carrier who gets to choose the physician in the first place, so they didn't really anticipate the problem or issues. But there are circumstances in which a company is unsatisfied with the physician they chose and So they just deauthorize them and authorize a new physician. We end up with big gaps in treatment if they say this physician's not authorized and we'll set you up with somebody else. So what this reg does is basically say the respondent and insurance carrier need to follow the same procedure as the injured worker, talk to the worker, see if if they can agree on a different physician. If not, they need to follow the process, the preliminary hearing process, and present evidence to the judge on a valid reason for changing the physician. The next one is 51-919, neutral evaluations, causation. This is only for neutral evaluations that address the causation issue, whether or not an accident is the prevailing factor causing an injury. Oftentimes in these litigated cases, you'll get a doctor that says yes, a doctor says no, and when the parties go to hearing, the administrative law judge will choose to order a neutral exam. Now, the administrative law judge technically has the right to make the decision on whether or not an injury is caused by the accident at work, but they often rely on these neutral exams. A lot of these neutral exams, they come back with a conclusionary opinion that it's my opinion the prevailing factor was the accident, or the prevailing factor was not the accident, it was some other issue, without any explanation. And so this just sets out some questions the doctor should address when he responds to the causation opinion, so that everyone knows how the doctor arrived at his opinion. We can avoid then follow-up letters which delay the proceedings further, or the deposition of the neutral physician, which again, sometimes those take months, several weeks to months to schedule and delay the process all the time, and injured workers going without any benefits. 51-11-7 is an average weekly wage. This was changed in 2011 along with multiple other changes, but it was changed to reflect that you look at the actual earnings in the 26 weeks prior to the date of accident and divide by the number of weeks the claimant the injured worker actually worked. But it didn't really address, if a claimant missed 3 days one week and 2 or 3 days the next week, another day through no fault and didn't get paid. So what we've done is kind of adopted, this was kind of followed Missouri law. This follows the Missouri statute or interpretation that if they've missed 5 days without pay for weather-related sickness, whatever, then you divide by 1 less week for every 5 days. So if it's 7 days, you still just divide by 25. If it's 10 days, then you would divide the wages actually earned during that 26 weeks by 24. And that's just to reflect a more accurate figure for the average weekly wage. The last one is the post-award application and cost. 44.510K allows for a post-award medical application. You can litigate your case. The injured worker may have medical left open if they were able to show they needed future medical. And then the statute says fees and costs can be awarded as part of the proceedings, but it doesn't define that. And the reason we put this in the expert, an exam with a physician and the cost for his deposition should be included as cost, is if they're not, it's almost prohibitive for an injured worker to seek further medical treatment. They may just want to go back and see a physician and get a prescription filled, or go back for a couple therapy visits. If the company denies that and indicates that they don't believe their current problems related, they're in a position of having to spend $800, $1,000 to get an exam and an opinion, take the deposition of the doctor and make their case in front of the administrative law judge. And, you don't want to spend $800 or $1,000 to pay for a $100 office visit or a couple $100 for therapy. So that's the reason that was included, to define that cost include an exam and the deposition costs of the doctor. That concludes my update, Madam Chair. If you have any questions.
Oh, I'm sure there'll be quite a few.
I'm
So if you
sure
would
I
just
have 4 friends back here that'll add some
around.
more comments.
Yes, thank you.
All right, thank you, Madam.
Up first, I believe we have Tony Anderson with Kansas Self-Insurers Association. Thank you for being here, Mr. Anderson.
Thank you for letting me be here. I do have written comments that I would share with the committee. I don't know how to do that.
I think we got them.
Do you got them all? Okay. Well, thank you, Madam Chairman, and the rest of the panel. We set out in our comments, our written comments, why we oppose all of these. There's really three main reasons. One is we don't believe that these regulations really pass muster statutorily. We don't think they pass muster with regard to invading the province of the legislature. And also they're all designed to increase the cost and the, if you don't mind the saying, throwing sand in the gears of how workers' compensation works. So legislatively, the statutes require that the director does have the right to promulgate rules to allow for the administration of the Workers' Compensation Act. If you look at each one of these are not designed to administer the act. They're not trying to make the act easier to administer. They're making it harder. And the first way is when we look at the rules that they have proposed is under 51.320, it really imposes new duties on the employers because it requires them to provide notices. Here's the thing, there's 45,000 cases filed every year in Kansas, and the director puts in his proposal, this isn't going to cost any more money to do this. Well, of course it is, because at every one of those cases, whenever any benefit is terminated, TTD, medical, temporary partial disability benefits, the employer/carrier has to provide some sort of notification. So that, and they have to give a reason. So now there's more paperwork that's involved. There's going to have to be more and more and more notification. Again, slows down the system, costs more money. With that, this is not a big problem because this is not a problem that we see all the time in workers' compensation. I've been doing workers' comp for over 30 years. The problem is that for the most part, claimants know when their benefits are being ended because the doctor says, hey, you've reached maximum medical improvement. You've gone back to work. Those two reasons are pretty clear. The claimant knows that. So we're not having this discussion every single case that the claimant doesn't know why their benefits are being terminated. And the second part of that is the legislature gave a number of reasons why benefits can be terminated as set forth in our written materials. Clearly, the claimant knows why they've been terminated. They didn't pass a drug test. They didn't show up for medical treatment. All of those are reasons why they didn't. It doesn't require a notification from the employer carrier to let them know that information.
Mr. Anderson, I
Yes.
hate to interrupt you, but we're limiting all of these testimonies to 5 minutes.
Okay, I will.
I apologize. I didn't tell you ahead of time.
I will speed along. As Representative Carmichael knows, I can keep going and keep going.
Because I was wondering, so I thought I'd tell you.
Oh, I appreciate that. I'll speak to the others in there. 51.9-10, it limits the employer's right to direct medical treatment. You all have passed laws that says the employer gives the right to direct medical treatment. Essentially what this says is, hey, the employer doesn't get the right to direct medical treatment. And number two is if they want to have a communication with the doctor about what's going on, You got to wait and talk to the claimant. You got to wait and talk to the claimant's attorney. That is really going to slow down the system. And finally, with regard to the very last one, because I think I'm into my end of my 5 minutes, and I'm sorry about that. On 51-19-2, that's really changing case law. There's a case out there that says we don't allow expert witness fees and expert costs to be included in the definition of costs under the law. The courts have already addressed this. So this clearly is a regulation that's trying to change the law. That's the province of the legislature. It's not the province of the administration to do that. So for those reasons, the reason we set forth in our written statement, we oppose all of these regulation proposals. Questions?
We'll just have you hold on off all the questions, and then people can come back and ask them if that's all right. Continue. Thank you. This seems to be a problem throughout rules and regs, that a lot of organizations and bureaus are trying to pass law without going through the legislature. This is not new. All right, our next testifier is Eric Stafford with the Kansas Chamber. Mr. Stafford, thank you for being here.
Thank you, Madam Chair and committee members. My name is Eric Stafford, Vice President of Government Affairs with the Kansas Chamber. First time before this committee, and appreciate the opportunity to be here on a beautiful sunny 70-degree day. What else would we want to do today besides this? I know Tony and I would like to play golf, but we're not afforded with that. Representative Carmichael, you're welcome to join us sometime if we're not doing this. Really, Tony can, through his testimony that he provided on behalf of KSIA, I think is spot on. I'd summarize our statements in 5 minutes or less by just saying that we have very strong concern that these are establishing significant policies that are in conflict with Kansas statute and or previous court cases and opinions. So it reiterates the point that I think it was Senator Tyson who said earlier. I know conversations we've had before, it stresses the importance of passing HCR 5014 or SCR 1609, which provides legislative oversight in that process. When we passed regulatory bill, actually with the great help of Representative Carmichael back in 2018, we were very limited what we could do because of that Stephan case. And so I think those constitutional amendments would help clear that up and provide stronger oversight by the legislature to prevent days like this from coming before you. So that would summarize our comments. Happy to answer any questions you have at the appropriate time, and appreciate the opportunity to be here today.
All right, thank you very much, Mr. Stafford. I didn't have to notify him, he only had 5 minutes. That was great. Now we have Jonathan Vogelai? Vogelai. Oh, sorry, as a proponent. Thank you for being here, sir.
Thank you for inviting me. I come here today as a practitioner of workers' compensation. It's basically the main crux of the practice that we have in Wichita. We represent hundreds of workers every year. I'm not an expert on Kansas administrative regulations, and I am not an expert on how those interact with statute. I would defer to the Attorney General, the Director of the Budget, and the Director of the Administration that have already approved these. However, I can tell you how these work within a practice and how it looks for workers within that practice. On the very basic tenets of work comp is that it is an exclusive remedy. If you are hurt at work, you do not get to choose your doctor. You do not get to choose your physician. What I am saying is you are stuck. You don't get to go outside of work comp or elect to go outside of workers' compensation. During that time period, your employer does get to choose not only who you treat with, but if they dislike the treatment for whatever reason, they can change the physician. Doesn't matter. They don't have to give a reason. They can stop it, no recourse. What we're saying is on these regulations, we are trying to clarify points that already exist within statute. We are trying to require that the employers send something to the claimant who's already living off of 2/3 of their wage and paying their fringe benefits to just say, hey, we're stopping it. This is why. The reason that's important, just from a practice perspective, if we have to file a 7-day notice of intent, and I know I'm getting into the weeds, but I'm going to try to make it quick. We have to file a 7-day notice of intent and then schedule a hearing through a computer program. That puts us 45 days out minimum. Generally, minimum 45 days out. So now we can go those entire 45 days without even knowing what the defense is going to be. And our client has no idea why they're cut off. They still can't go to work. We haven't heard anything. They can't employ their health insurance benefits or their long-term disability benefits, which they have been paying for, because they will not cover work comp. All we're asking is a very common courtesy to say, hey, we're shutting it down and this is why. If we get a denial letter like that, they can provide it to their health insurance or provide it to their short-term disability carrier, and they can, I guess, invoke other benefits which they already have. Sorry, there's 6, and I know I'm talking fast, and we are asking, within the bounds of the statute, that we get communication that is coming from the insurance company to the doctor. I'd like to clarify, the doctor is not the client of the insurance company. They are selected. During that time period, while they are the authorized treating physician, they are under no obligation currently to share communications that they have, a non-practicing medical individual, that they have with the doctor to direct treatment. Sometimes it's a nurse case manager, sometimes it's an adjuster, sometimes it's an attorney. But I think everyone in the room knows that if that happened outside of the bounds of work comp, to where your insurance company directly communicated with your provider and didn't share that information and you were denied treatment based upon that, sorry, I'm not crying, I'm just trying to breathe and talk, it's tough. But look, it outside of those bounds,
It'll be okay.
I know we got 5 minutes and 6 regulations, I'm trying to hustle. But my point is, if that was done outside of those bounds, it would be absolutely horrifying to everyone in this room. But that can happen and often happens. The only thing we're asking in this regulation, the only thing that has already been approved within the bounds of statute is to share those communications. If you have a verbal communication, have someone there, such as an attorney that you've hired or yourself, that can be a part of those conversations because it is your care. They are still patients, even though they are work comp patients. And I think that's very important. Another thing I would like to say, we are looking at this neutral physician question. I put in my written testimony, which I'm sure you have, that it is a lengthy process. Currently, some of the most commonly used neutral doctors are scheduling in February. That is after your 7-day notice of intent. That is after 45 days to get into a hearing. And then you're still waiting to February of 22. If I started today, no one's gonna get seen until March, maybe April. The point is with that, when you go to these doctors, it is a very important appointment. So what we are asking is a standardized list of questions that come out, because what we are looking to do is get the information required by case law to adjudicate the case. We are looking to make it easy to move it forward. Those are questions the judge will look at, no question. We are asking them to address it because we use a variety of doctors, some of which are very familiar with work comp, some of which are not. Because if you have an injury such as your eyes, it's not a very common work comp injury. They may not be familiar with statute. So what we're looking to do is standardize the questions and make the process more efficient. Last, the average weekly wage calculation that we use. How am I doing? Am I getting there? All right. The average weekly wage calculation is important because if you have clients that miss 4 days during a week, it's counted as a full one. The language in the statute is dates or weeks that are actually worked. And currently what that means is if you work 1 hour of 1 week, it's a full week. It's the bounds of the statute are those terms, and they have not been defined yet. What we're asking for this regulation is to further define that and say the weeks you actually work count on the days that you actually work. So it doesn't bring down your average weekly wage, which is important for every aspect of the compensation in your workers' comp case. You're paid 2/3 of that during it, which you're still paying fringe benefits out of, which is a huge burden, but that's another story. Point is, that calculation means everything to your case. So it's not something taken lightly. And if you are working 1 day out of the week, it should not count as a full week. The statute already says weeks actually worked. What we're asking for is to define that. Last, costs. Same thing. Cost is already in the statute. We are looking to define that because the only costs that you generally incur in a work comp case are going to be getting the doctor, getting their testimony, and getting the report. All right, how'd I do? Very well. Thank you very much for having me. I do appreciate it.
I do want to just, I think one of the most misunderstood things about this committee is that it goes to different places like the Attorney General and the Office of Budget and the Secretary of State. They're not looking to see if the ins and outs so much as they're looking at it for their area, period. So they don't come, very rarely do we come up with something saying, "Hey, you guys aren't going to like this," or whatever it is. Thank you. We'll just move on.
Madam Chair, if I may,
Yes.
my understanding was that the Attorney General had looked at those for this specific conflict.
Did.
Okay, I was just making sure. I make sure I
Making
understood.
Sure, yes. And their job alone is to make sure that nothing is out of place in terms of the legality of it. I don't think that's the problem we have with it right now. I think we have the problem of legal and legislative information being decided by bureaucrats and not by the legislature.
I appreciate your time.
All right, thank you. We'll invite Jan Fisher to come up now. Thank you very much for being here, Ms. Fisher.
I almost feel like I need to take a breath after John.
I know, I was out of breath too.
I have been a claimants attorney.
I'm sorry, could you just introduce yourself?
Yes, I'm sorry. My name is Jan Fisher. I've represented injured workers for about 36, 37 years. I also teach work comp at Washburn. One thing that I know from 36 years of practice is that work comp is a very dehumanizing experience for the injured worker. Most of the people that I have contact with, they don't want to litigate their case. They just want to get well. They want to go back to work. There are salt of the earth, hardworking Kansas, and they just want to participate in the process and get back to work. And I think that these regulations make an effort to allow the person a little bit more dignity in the system, and it makes it a little bit more open. You know, I heard Tony say the injured worker knows why they're cut off. Well, respectively, no, they really don't. Because I've represented claimants for 36, 37 years. Tony has not. And they don't really understand the system. They don't understand when the doctor says you're at maximum medical improvement, that means that your check is going to get cut off. And you need to figure out, what am I going to do? How am I going to pay my mortgage? Should I file for unemployment? Should I go talk to my employer? They don't really understand that because they've never been through the system like we have. And so all we're asking is that they have a note that says, yeah, you've been cut off. This is the reason you're cut off, and you probably need to do something about it. It seems like a common courtesy just to treat them with a little dignity. And the second KER that talks about medical reports really is the same thing. It's adding a little dignity to the system. Don't treat them like they're claims, treat them like they're human beings. It's their body, they're the ones that are getting the treatment over this, and they want to participate in the process of getting better and going back to work. And so that's what this allows happen. I don't know how many times as a claimant's attorney, I've had a scared phone call from an injured worker, and they'll call up and they'll say, well, I went to the doctor, and then after I went to the doctor, the insurance adjusters, we call them medical managers, I hate that term, but they're nurse case managers that come in and try to work on the case and try to move medical forward. Well, they're over in a little corner and they're talking about my case and I didn't have anything to do with that. That might be a perfectly legitimate conversation to move the case forward. But what does the injured worker know? He knows they're talking about my body. They're talking about medical treatment that I need to get better and go back to work, but I don't get to participate in that system. And that's all we're asking. Either that they get a copy of the correspondence or that they be allowed to participate in that conversation. Not that the insurance company can't direct the treatment, only that the claimant be allowed to be treated with dignity, to be treated as just a person who wants to get back to work. The third KER that talks about once a treating physician is designated, then we need to stay with that treating physician. You know, I've been doing this a long time, and I kind of went through the AMA guidelines, 6th edition fight that we had. And we always used to say, our doctors are good in Kansas. Let our doctors control the medical care with help from their patient and with help from the insurance company. And all we want to do is not stop treatment. And sometimes what happens is the insurance company, maybe for totally legitimate reasons, thinks they need to change a treating physician. All we're asking is that the treatment continue while we have that process. And the other thing that I've really found in 36 or 37 years of practice is that delay always hurts everyone in the system. Tony and I have a case together of a nice lady, unfortunately she just passed, who tore a rotator cuff. And you know, usually no big deal. Go in, fix it arthroscopically, go back to work. But because of delay after delay after delay after delay, that woman ended up having to have a reverse total shoulder. And I'm not saying that was the claimant's fault. I'm not saying that was the insurance company's fault. I'm not saying it was anybody's fault. But the system let that lady down because she went month after month after month without medical treatment because of the way the system was set up. So I really think that anything we can do to keep medical treatment going, to get these people back to work as soon as possible, is appropriate. The KAR on neutral evaluations, our law now says the accident must be the prevailing factor in the injury, the medical condition, and the resulting disability or impairment. We're fine with that. The issue is, how do we decide that? Because in some ways it's a legal issue, but in some ways it's also a medical decision. And so what our judges frequently do is they'll have one doctor say one thing and they'll have another doctor say another thing. And so they say, okay, let's do a tiebreaker. Let's do a doctor that we all agree is a good doctor who knows what's going on and will give us an opinion. Well, then that doctor gives us an opinion, and sometimes it'll just have the one statement, it is prevailing factor or it's not. And so we'll have questions about that. And so what happens? Well, we can't talk to that doctor unilaterally. So we have to have an agreement, and we have to put a joint letter together, or we have to do a deposition. So that delays the system more. So the idea is, let's try to get more information out of the doctor on why he made an opinion. It reduces litigation because everybody knows what's going on, and it also reduces delay so people can get their treatment and get back to work. The next regulation is the wage regulation. I don't know that that's really all that controversial. All we're trying to do is look at that statute and not pay people a wage based upon an artificially inflated number, and not pay based on a artificially deflated number. Just look at what they actually made, what they actually normally made, and that's what the statute calls for. And that's why the reduction in the wage, only if you have a regularly scheduled day that you don't get paid for. It's not giving them more time than they actually have. The last one is cost. The first thing I always tell my clients when they walk in the door is, the money is there, that's fine. If you have a permanent issue, we'll deal with it. But what's the most important thing under the compact? It's the medical care. And what we're talking about is those few people that have permanent injuries and they need long-term medical care. Well, our Blue Cross Blue Shield and our Medicare, they won't cover anything that's work-related. So they can't use their private insurance if they're 10 years down the line to find out, hey, I'm having back pain. I had back pain with my work injury. Is this work comp or is it not work comp? So how do I get into the doctor to even find out whether this is work-related or not? And that's all this does. It's completely discretionary. The judge can say, no, that wasn't in good faith. We're not going to award the cost. But this is a way for them to find out, is it work-related, is it not work-related, and who should be liable for that, the insurance company for the work comp carrier or for private insurance. So as I said, after 37 years of this, I would like to see all of my clients come out of the system saying, I got treated fairly. I knew what was going on. I was allowed to participate in the system. I think these regulations take a step toward that. Thank you for allowing me to comment on them.
I would like the committee and everyone to note that we have also additional testimony from Natalie Bright for the Society for Human Resource Management. And so you take those into consideration as well as the oral testimony we've just heard. Does anyone have a question or comment about all that we've heard? Senator Faust-Godot.
Thank you, Madam Chair. So I want to first say that notification, I think that's really important. Legislation I introduced and passed into law at one time was to notify the family of individuals who were killed in drunk driving accidents. There was a educator in the city of Wichita, and her son was killed by a drunk driver, and that drunk driver was released back to the community that was near her home and the school where she taught. And she ran into him one day. It terrified her. And so now on the books, we notify individuals that are being released from prison and back into those neighborhoods. So with that said, real quick questions, Madam Chair, I have, and I'm going to talk fast like that gentleman over there. So I wanted to, not a question for Jan, but just a comment. Thank you for your down-to-earth presentation. My mother used to say, no decision made about me without me at the table. And Madam Chair, I always wanted to be an attorney. However, I'm not. But I get to work with a lot of attorneys, and it's an honor to have the attorneys in the room today. My first quick question is for Mr. King, and as you are approaching the podium there, so to support your request on the notification of termination of benefits, so do you have complaints? A list, a number of those complaints made to your department to justify this proposal?
I don't have a number of complaints. If you talk to any attorney who represents injured workers or complaints, I primarily did defense work, but I also represented injured claimants some in that Kansas Workers' Compensation Fund. I was in practice for 38 years in private practice. So, but yes, if you deal with anybody in the work, I can't give you any numbers. I don't have any kind of.
Madam Chair, so sir, you're hearing from others though that this is a problem.
Oh, certainly.
A concern. Okay, thank you. And then Madam Chair, my next question is for, thank you, Mr. King. If I may, Madam Chair, my next question is for Tony. Since everybody, and I'm sorry, sir, I don't, if you'll state your name again.
Tony Anderson.
Thank you, Mr. Anderson. I have to be careful to follow my colleagues' lead sometimes. So Mr. Anderson, so wouldn't we want people to be notified to that their benefits are going to cease, not to cause confusion?
Overall, you're correct. It'd be nice to have people be notified, but here's the thing. They are notified in probably the vast, vast, vast majority of the cases. Because when the claimant ends their medical treatment, they're talking to someone from the carrier or from the employer, and they're telling them that your medical treatment has ended or that your temporary total disability benefits had ended. So it's an oral notification. What this requires is a written notification with an explanation to that. Again, there's 45,000 cases a year. So, and every time a benefit is terminated, you have to give that notification. Why does that notification need to be in writing versus it being done orally, which is what is being done now? So that's the challenge with the regulation.
Sure. Thank you. And Madam Chair, thank you, Mr. Anderson. So then my next question is for our dear friend Eric Stafford, if you may, while you're coming forward. So, I mean, so what's wrong with just an email being sent, again, to prevent that confusion? Perhaps if there are changes in the physicians, or if that physician can't make it in the room that day and they're not on duty and then another physician comes in. I mean, what's wrong with just, therefore, it's no problem with the individual receiving the comp benefits and the employer and the physician. What's wrong with an email? It wouldn't cost much.
Is this a separate issue? You're talking about the choice of physician, or are you talking
No.
about the notice for the termination of benefits?
Madam Chair, Eric, the notification of the termination of the benefits.
I think it just deals with the additional burden on the carriers and employers to provide that notice when, again, and you're dealing with workers' compensation where 95% of the cases, and that's just a hypothetical number, that's not a real statistic, but basically, by and large, strong majority are not litigated of workplace injuries. So I think to Tony's point that he made during testimony is the individual is aware as they are cleared to go back to work and return to work, they've reached the maximum medical improvement. They are aware. So to add that burden for notifications, we're not really clear why it's necessary. And there are administrative costs. The more you're asking employers or carriers to do, there are costs and time associated with compliance.
Sure. And Madam Chair, and thank you, Eric. So for the gentleman that was the speed talker, so are you Slapin Howard? Yes. In your name?
Jonathan Vogelai.
Mr. Vogelai. But you're with Slapin.
I am.
Slapin Howard. I see them on the TV all the time there in Wichita.
I'm glad the advertisers
And so it's a pleasure. Madam Chair, I feel like we're just we have celebrities in the audience today, all of you. Thank you.
I'll tell you a secret. If it's advertising, they'll put anyone on TV.
So, Madam Chair, this is my last and final question on this topic. Sir, so you kind of mentioned the changing of physicians.
Yes.
And so in that scenario that you gave, which physician would be the one to notify their patient that their benefits have ceased?
We're looking for a notification from the carrier, and I don't think it's just beneficial for the claimants in our case. I'd point to a case called Hull, Hull v. Spirit Aerosystems. It's a case that my firm tried, and there was $250,000 approximately of medical which was incurred by a claimant because they were not notified that they were unable or that they were cut off from benefits. Went to the Court of Appeals, and the claimant was awarded that money. The point is, notification in work comp means a lot to liability for both the claimant and the respondent. This helps respondents out as well, saying, hey, we are not paying for anymore, and it's a very clear notification that they can show the court that cuts off their liability. Currently, there are statutes that if they cut off benefits and within the statute, we can pursue those benefits if there's ambiguity as to whether they were actually terminated. This is not just a thing for claimants. This helps us in a practice because we know why and when they're going to be shut down. But it also protects respondents as well. This is a good practice for them. So I wonder how many letters you can write for $250,000, because I assume it's a lot. And I assume that it will pay for itself in one case like that.
Madam Chair, thank you so much. Thank you, sir.
Yes, is there anyone else on the committee that would like to say anything? Excuse me. Senator Tyson. After Senator Tyson, Senator Warren, I will call on you. Thank you.
Thank you, Madam Chair. Again, I know it was mentioned during testimony and earlier today, but this is a prime example of why this committee needs some veto authority. I think this is overreach by the department. I wish that they would pull the regs and not go forward with them. I understand that the previous parties that are involved in the process have signed off, but they're looking at it from, as you said, a legal perspective, not whether this was the intent of the legislature or not. So thank you, Madam Chair.
Thank you, Senator Warren.
Thank you, Madam Chair, and I want to follow up on those comments from Senator Tyson and some of the earlier testimony and statement from Madam Chair as well. This is legislation by bureaucrats. It is going to significantly impact a very, very complex area of the law. I do not profess to be an expert in workers' comp law. I have not practiced it for 36 or more years, and do have, the process is to get injured workers back to work. And it is the exclusive remedy for workers who are injured on the job. But again, it's a very complex bargain, if you will, that has been struck between the system of employers and employees, so that injured employees do not have to litigate. The term litigate has been thrown a lot around today by our discussion, and filing a claim is different than what lay people may think of as litigation, where you have to prove that the employee or the employer was negligent in order to get your benefit. So it's a different system that has been exclusively set up for the purpose of helping employees in the process of getting back to work. There are 5 brand new proposed regulations here, and I could go through them one by one, and I will spend a few minutes on a couple of them. The last one in our packet, 5119-2, post-award applications and costs. Oh, excuse me, hold on a second.
Please, Mr. Vogelai, please sit down. Yes, I apologize. I should have told you to go ahead and do that.
Okay, I'm sorry, doing this from home. So there are no costs for expert opinions currently required by the statute. This new regulation, contrary to the testimony we heard, does not make the awarding of costs for the employee's own expert discretionary for the court. It says costs shall include the cost of an expert opinion. And again, this is very complex, and hate to get into the weeds here, which is why it is not proper for this regulation to be possibly enacted and put into law without going through the legislature. This is a huge change in the worker compensation system, because if you've got lifelong permanent injury as a result of a work-related injury, you as the employee then can go get an expert, hire an expert who costs hundreds of dollars an hour, if not more, and who is likely to opine that you, the injured employee, needs more medical benefits. And the employer then is going to be expected to pay for that opinion. And it's complicated, and it just needs to be vetted further, because it impacts employers, it impacts employees, and we need to do it not by bureaucrats, but by the legislators elected by the people. The average weekly wage, that is a huge change in law, not in regulation, but in law, enacted by the legislature, previously enacted by the legislature, that this attempts to, I would say, circumvent the legislative process. I'm talking about 5111.7, the average weekly wage. That is going to impact the system hugely. We should not be changing how workers' compensation benefits are calculated through mere regulation. It is a legislative issue, and it needs to be addressed there properly. Same thing with 51.919, the neutral evaluations and causations. My understanding is in the field of if you will, independent medical exams, IMEs, as they're known. When you are an injured employee, an injured worker, then you go get your IME, which is then becomes, I believe, your treating physician throughout the claim process. To require, I believe there's only a handful of practitioners in Kansas that handle most of those cases. I believe it's probably less than 10. So 51919 imposes these 6 additional questions that aren't required by statute and imposes them on other physicians who might be providing IMEs. And is it going to expand the pool of physicians willing to participate in providing IMEs, or is it going to further constrict it to the very narrow pool that we have currently? And again, these are brand new regulations. These aren't amending what we currently have. Again, 51918 designating the authorized treating physician. This will actually slow down the process if you're having to go through this regulation to change physicians. Inside of this bargain, if you will, between the employers and employees, workers in the state of Kansas. It's not necessarily you go get a job and you have agreed personally to this bargain. It is the state policy of Kansas to provide workers' compensation in circumstances where, now I'm not going to use the correct language here because, again, I'm not a practitioner who's practiced 36 or plus more years in the area, but you have to show you were at work, it was within the course and scope of your employment, things like that, that we as a state have set this process in place for helping injured workers get back to work. So to change it like is proposed here is very concerning. Even the one of the 6 regulations that has been brought to us today that is an amendment of existing regulation, and that's 519-10, it's no small amendment. If you look at it, it's several paragraphs, including that governing the written reports and where they're sent and time limits. I believe these are things better determined by the legislature, and including all notifications that are included in these 6 regulations. So you'll hear when that these are policy issues not determined by the entities that have stamped the proposed regulations that are provided to us today. The Division of the Budget, Department of Administration, Attorney General, Secretary of State, they don't decide these policy issues. They have their reasons for looking at this as they're required to do. So I am very concerned about the breadth and depth of these proposed regulations on a very complex system. And it's something that should be considered by the legislature, and the legislature both in its committees and the legislature as a whole before these would be promulgated. So I'm concerned if these move forward as they're written. I'm also concerned that we as this committee don't have the authority to amend or otherwise change or revoke or strike these, which is why I think as we heard testimony regarding the concurrent resolutions currently in committee in the Senate and the House, that they need to be looked into, Madam Chair. Thank you for allowing me, I think, more than 5 minutes to explain that.
I believe committee members were not restricted to that so much. Not so much. Not so much.
We'll appreciate the ability to have my say.
Thank you. Thank you, Senator. Was there any other committee member? Representative Wagner.
No, thank you, Madam Chairman. I don't have that much to follow up. I think Senator Warren really covered a lot of the bases extremely well. I mean, being my day job where I run a manufacturing company with, 24 employees, I mean, work comp, has been a very big issue over the years. The reforms the legislature put in, I believe in 2011, really did make a very tangible difference. Besides the fact that this does seem to be end run on some of what the legislature has done, which I think some of the conferees have explained, as well as Senator Warren. I'm also a bit taken aback that by our economic impact statements, that somehow the agency can get away with avoiding that somehow this has over $3 million of total impact. I mean, workers' comp is a very big cost to companies. That when you're making changes like this on how wages are calculated and other fields that do affect what your cost is going to be as far as how you will be charged, what your potentially your modifier is and such, that there is some fundamental flaw in how agencies are approaching this economic impact statement, would be my other commentary. But again, I do hope that the agency would reconsider, and I do hope that this committee, whatever power it has, can see that it goes through the legislative process and not through rules and regs. Thank you.
Thank you. Representative Sutton, please.
Thank you, Madam Chair. And actually, for the sake of brevity, I think between Representative Wagner and Senator Warren, they've covered the vast majority of the points I wanted to cover, so I'm not going to repeat that. It does look like the vast majority of this is a reaction to what was passed by the legislature in 2011. 10 years later, we have questions. To the point that we're even looking at Missouri legislation, also passed by the legislators, to determine the average weekly wage. I'm not elected in Missouri. I'm not sure some of you on the borders might be. I'm not positive, but using Missouri law legislation for a regulation here in Kansas, I find to be, well, uncalled for. This is something that needs to be handled through the legislature. If there are blanks that need to be filled in, I'm happy to talk to the agency to work that out when we pass our legislation. But that's really where this work needs to be done. By the way, when we're on the floor, if we're discussing 5111.7, I've got some great stories on that one. So, and I think Paul, as a manufacturer, or Representative Wagner, as a manufacturer, would also probably have very similar stories. I would be opposed to that no matter what. But I do think this is something that needs to be handled by the legislature, not handled through rules and regs. Thank you, Madam Chair.
Thank you, Representative. I believe Senator Warren took her hand down. I wanted to make sure that she had made the decision to not make another comment, if she would so tell me.
Sorry, I was shaking my head. Yes, I've taken my hand down. Others have. You're all hoping, right? So
All right.
I hope I stress strongly enough that, like Representative Wagner and Representative Sutton said, this needs to come through the legislature as a whole. And I'm very concerned about the end runaround that we see occurring here.
All right, thank you. Representative Carmichael, you have under 10 minutes for sure.
Thank you, Madam Chair. I agree with you on that point. Entering into this contest about who's practiced workers' compensation law longer, all I can tell you is I started on August the 2nd of 1982. So I think Mr. Carnes may have me beat over there. Ms. Fisher might have me beat. I'm not sure about Mr. Anderson. Apparently not. By the way, I don't have any active workers' compensation cases anymore. The Kansas legislature has done its part to destroy my practice. That being said, In response to Representative Sutton's concern about why it is we often look to Missouri law, when we passed these amendments back in 2011, I think Mr. Anderson can tell you, Ms. Fisher was present, I think Mr. Carnes was actively involved in that as well. We adopted a test from Missouri that was known as the prevailing factor test, and that was a sea change in Kansas law. And while we didn't import it carte blanche, we certainly looked a lot at what had happened in Missouri. And so I think practitioners in Kansas are oftentimes prone, rightly or wrongly, to look and cite to Missouri law, particularly as to how it relates to the application of the so-called prevailing factor test, which is a causation standard, and what evidence is necessary. I think that's part of what this regulation about doctors' independent medical examination reports is about, is set out the factors that caused you to reach the conclusion that you reached. That way the judge can weigh the independent medical examiner's report with perhaps a report or a deposition from the authorized treating physician, that being the doctor that was authorized by the insurance company, and compare the weight of that testimony with perhaps what an unauthorized medical examiner for the injured worker concluded. Because unfortunately, what happens to us is oftentimes we get back a paragraph from one doctor that says the injury is the prevailing factor. We get a paragraph from another doctor that says the work injury is not the prevailing factor, and the judge somehow has to figure out which one he or she is going to adopt. So I just wanted to share with you at least that that's why you sometimes hear us refer to Missouri law, not with reverence or respect, but just as the historical basis for some of what our law is. Thank you, Madam Chair.
Thank you, Representative. Is there any other comment? I'll try to close this up myself. I continue to be horrified that staff who are unelected and unaccountable are making law. And I'm not just going to pick on the Department of Labor. I'm talking about all of you. This cannot continue. We cannot create law by rules and regulations. And you will pay for this. I'm telling you, you will find out. I'm doing everything I can to let our constituents everywhere. This is a huge problem. We are held accountable for everything we do. We get in and out of office. We come and go. We're used to that. But when your departments create legislation without any responsibility, every Kansan loses. I guarantee you, every one of us loses. And when you say, oh, we need to do this to all these things, it's a huge problem. And I would hope that every legislator would tell their constituents and everyone in Kansas that bureaucrats are creating law every day through rules and regs. And you don't have a word to say about it. So I ask, which I have no power, I can't tell them they have to, but I don't want you to do anything with this. I beg you to wait until the legislature comes back in session. I happen to know there are quite a few people that would be willing to sit down and go all through this with workman's comp law. Do not change the law by regulation, I beg of you. This is totally wrong. I'm not even discussing who's right and who's wrong in terms of proponents and opponents. I'm talking about do it in the place that you should be doing it, within the legislature, within state law. Does anyone else have a comment while I let my blood pressure go down? That's not very good. Anyway, I would like to request that the Department of Labor, in our comments, do not do anything with this until we can get back into session. And I promise I will be the first one to stand up and say, I will help you. Work on it. Pro or con, doesn't matter to me. All right. Take a deep breath. You know what, maybe we should take a few minutes. Listen, I, for one, need to use the ladies' room. Could we adjourn for, well, I just thought I'd tell you that I'm not leaving because I'm getting my blood pressure down. I would like, if we could just adjourn for about 5-10 minutes at the most, just to take care of business. Recess, I apologize, recess. Thank you. I apologize for people who are waiting. Okay, now that we've all had a little bit of a break, thank you very much, people, for allowing me that. Let's now move on to the Kansas Bureau of Investigation. I believe we have Kelly McFerrin. Is she here in person? Maybe not. Okay. And then we also have Krista Knox, Chemistry Supervisor via WebEx. Thank you for being here.
Good afternoon, Madam Chair and members of the committee. Can you hear me okay?
Yes, we can. Thank you.
Perfect. My name's Krista Knox, and I'm the Chemistry Supervisor of the Kansas Bureau of Investigation. I'm appearing before you today to talk about KAR 1022-1, which KBI is seeking to amend. As background, KSA 22-2902C allows for a court during a preliminary examination to admit into evidence an alleged controlled substance if certain requirements are met. One of those requirements is that the alleged controlled substance has been subjected to a field test approved by the director of the KBI. KAR 1022-1 is the regulation specifying those approved field tests. It contains reagent-based field tests and instrument-based field tests. We are proposing the addition of 3 instrument-based field tests to subsection C of the regulation. Those field tests are the Thermoscientific First Defender RM Chemical Identification System Handheld Raman Analyzer, the Thermoscientific Gemini Analyzer Handheld Raman and Fourier Transform Infrared or FTIR Analyzer, and the Smith Detection Hazmat ID Elite Handheld FTIR Analyzer. Each of these 3 instruments can indicate specific controlled substances in the field and have been evaluated by the KBI chemistry section for ease of use and suitability. The addition of these instruments to KAR 1022-1 will provide further options for law enforcement agencies to equip officers in the field. Thank you for your time today, and I'd be happy to answer any questions you might have.
All right. Does anyone on the committee have any questions or comments? Representative Sutton.
Thank you, Madam Chair. I hadn't actually gotten to one yet, but I was just, we've got 3 new testing mechanisms here. I'm assuming they're good. This is the first I've heard of them, so I'm just a little bit caught off guard here, that's all. That's why I wasn't really raising my hand. I was kind of shrugging, going, what is this? Yeah, exactly.
I know that Senator Warren would like to make a statement, but I would like to ask Ms. Knox, if you could explain what the Raman does. I know that I talked to someone this morning and they said that you've been trying to do this for some time. Could you explain in layman's term, please, exactly what this Raman is?
Yes, ma'am. Each of these instruments are able to detect substances based on how different compounds react to either in the Raman to laser light, or the FTIR is infrared light.
Okay, so how does that help you? I think that's what we're asking.
Sure. So essentially, different compounds will give different unique spectra. So in the field for the officer, if they have a potential sample, they could potentially see in what is in that sample.
All right. Senator Warren, would you like to speak? There's feedback. Is that? Senator Warren.
Is there still feedback?
No.
Okay. Thank you, Madam Chair. I don't have a statement, have some questions. Appreciate that this looks like new tools for our KBI to use. Could you list or tell us what controlled substances these tests would be used for?
Yes, ma'am. So these instruments would be used for a variety of controlled substances, basically anything that the officer would or could see on the street. So they
Does
would
that
test for all controlled substances.
Does that include marijuana?
No, ma'am, it does not include marijuana.
I think the feedback is because we both have our microphones on at the same time. There we go. Does that help?
Yes.
Thank you. So not marijuana. Does it help test for CBD? Turn my microphone.
No, ma'am. The cannabinoids, usually what officers use for that is one of the reagent-based tests that's already on the list.
So not to be difficult, I'm just curious, I haven't heard a specific controlled substance that, just for, educating us and the public, that this would be used for.
I apologize. I misunderstood your question. It could be used, for example, for methamphetamine, cocaine, even fentanyl. Those are just a few examples.
Well, that's good to know. Thank you. Does that also include other opioids other than the ones you've listed?
Yes, ma'am.
Thank you. Well, good to see that we have, like I said, some more tools in our toolbox to combat this. Thank you.
Yes, Senator Faust-Cadeau.
Thank you, Madam Chair, and I'm sorry I did everything backwards. I just came from the restroom, so I missed if the conferee would actually say again this testing. So is there a device with this testing, and when would the testing be made? And give me an example of a scenario of, you're talking about you get pulled over for a traffic violation and then this testing is just automatically performed. I mean, help me, please elaborate. Thank you, Madam Chair.
Ms. Knox?
Yes, if I may. So these are three separate instruments. So they are handheld pieces, devices that law enforcement agencies have the option, if they would like to equip their officers with these handheld devices, they can. So if an officer is using one of these in the field, he would have it in his patrol car. If he pulled someone over, as an example, and they had some substance in their vehicle, the officer could then test that right in the field, and they would be able to identify that substance while they had the person pulled over, or before they had sent it to the lab. And then the officer would then send that substance into the lab, sort of as confirmation for that seizure.
Sure. If you
Thank
have
you,
another
Madam
question.
Chair. So then the officer gets to be the judge and the jury and make that decision all right there during that traffic stop. And who would pay for this device, and how efficient is this device? Madam Chair, I'll be honest, it's kind of concerning. Over the years, I've worked really hard on racial profiling issues and that pretext stop and just those concerns. So I'm going to read a little further. And then, Madam Chair, and to the conferee again, so how much would this cost and who would pay for it? I mean, we've still not totally implemented body cams throughout the state of Kansas for our officers. And so I like tools in a toolbox. We throw that statement around, but this is more than just a screwdriver or a flashlight in a toolbox. This is I would really want to know how efficient this device is, how accurate it is, and if it's not another tool in the box, just, okay, we've stopped a person, now we're gonna do all these different things on site. And Madam Chair, not that they're correct, but I've watched some detective shows. I like to watch those quite a bit. Actually, I watched a lot of Law
and Order?
Yeah, yesterday, actually, I did. And, you know, when they stop people, they already have. I thought we already had certain, like to test cocaine, a little test tube like deal that they carry with to do these testings. Why do we need this right now? Especially with COVID and, um, uh, I don't, anyway, how much would it cost? Who would pay for it? And how efficient is it? And why do we need it right now? Thank you, Madam Chair.
Ms. Knox?
Thank you. So we are not actually asking anyone to, or requiring anyone to purchase any of these instruments. This amendment is simply giving more options to the law enforcement agencies should they so choose to purchase an instrument. There are other instrument-based field tests and reagent-based field tests already on the list that they also utilize. So I hope that answers that question. How efficient and how accurate, I would have to gather that data out of the studies. When we do get a request from law enforcement to look at one of these instruments as new technology comes out, we, in the chemistry section, we analyze these instrumentation as it's requested, and then we essentially provide a recommendation to our own internal committee, which includes a supervisor, a technical lead, multiple scientists, and then we make recommendations up through our laboratory executive staff to the director of the KBI, and he can choose to approve or deny the addition of these instrumentation to the KAR. And you asked, why do we need this in addition to what's already there? Truly, we're just trying to provide more options to our law enforcement agencies in Kansas, as well as these instrumentation for the Raman especially, you don't have to actually open the sample and take a sample of the substance. So it adds a level of safety for the officer, especially when you are talking about those substances that are dangerous in very small quantities like fentanyl is.
And Madam Chair, if I may, and then the cost, who would pick up the cost? Thank you.
Yes, ma'am. So the cost of the instrument, again, we're not requiring law enforcement agencies to purchase these instrumentation, but if they do want to equip their officers with that, the cost would be at the level of the agency that's equipping their officers with it. So it would be the local agency.
Just one more question, Madam Chair. So,
yes, ma'am.
So, but where would the funds come from? Internally, or would, I mean, where would they get the money to pay for this if they so choose to purchase an additional tool for their toolbox? Thank you.
Yes, ma'am. I don't know the answer to that. That would be up to the individual agency to determine.
Senator Warren.
Thank you, Madam Chair. Any defense attorney could then, with these instruments, just like with other instruments, question, well, was it properly calibrated? Was it properly used? Did you keep the substance properly in the chain of custody? So it's not the judge and the jury and the finder, all that there on the scene, if you will. Am I correct? Because you still have all those questions that you can direct to the test if it comes later to a court case, correct?
Yes, Senator, that's correct.
Thank you. And that would take care of some of the questions about did the test work properly and what were the results and were they reliable results? And was it reliably administered, things like that? Thank you.
Is there, yes, Senator Faust-Godot.
Madam Chair, I just want to thank the gentlelady, Senator Warren, for her explanation on that. Thank you.
I also was told this morning, because of some of the dangerous substances, the infrared and the laser can also give them a good idea of what's going on so that the police officers or investigators aren't touching something before they get it to someplace safe to be tested. That, Ms. Knox, would you tell me if that was somewhat correct? Because I'm not a law enforcement agent, but.
Yes, Madam Chair, that's correct.
Okay. Are there any other questions or comments? All right, thank you very much for appearing before us today. I think you are off the hot seat. Now we'll move on to the Kansas State Board of Regents, and I believe we have Julene Miller, General Counsel here. Thank you for being here, Ms. Miller.
Thank you, Madam Chair, members of the committee. My name is Julene Miller, and I am the General Counsel for the Kansas Board of Regents. And I also have here today Daniel Archer, who is the Vice President of Academic Affairs for the board, Samantha Christie Dangermond, who is the Director of Academic Affairs for the board, Matt Melvin, who is the Vice Provost for Enrollment Management for the University of Kansas. And these folks will help me if you have questions that I am unable to answer as we go through. I thought it might be helpful to start with just a really short history of the board's qualified admissions regulations to give some context to why there are 5 articles and to give some context to the regulations that are actually in front of you today. So if I may, Article 29 is the board's original set of QA qualified admissions regulations that were adopted to implement the qualified admission standards that are set forth in the statute in KSA 76-717. Then when the legislature amended that statute in 2009 to allow the Board of Regents to set standards that differ from those established in the statute, the board adopted Article 29A for the new standards to be used by Emporia State University, Fort Hays State University, Kansas State University, Pittsburgh State University, and Wichita State University. And a year later, Article 29B for the new standards to be used by the University of Kansas. Article 29 was left in place because KSA 76-717F requires a 3-year lead time for any new standards that are considered more rigorous than those that are established in the statute. So that would give high school students a full 3 years to meet those requirements. So while Article 29A of the regulations were first adopted in 2011 and 29B regulations were first adopted in 2013, they were not effective until the summers of 2015 and 2016 respectively, with students seeking admission prior to that time continuing to be subject to the Article 29 standards. So we had to have all 3 in place for different cohorts of students. Article 29 regulations are being phased out as subsequent regulations become effective for the new cohorts. With the revocations the board is currently seeking, there will be only 4 Article 29 regulations left, each addressing issues that have not changed over time, at least for some of the universities. So then in 2020, the board adopted changes to the standards for all of the state universities. Those changes were not considered more rigorous, consisting primarily of eliminating the board's qualified admissions curriculum, and therefore did not require the 3-year lead time. But because there was a need to clearly delineate which cohorts would need to meet which standards, new Article 29C and new Article 29D were developed to take the place of corresponding Article 29A and Article 29B standards for the students applying in the summer of 2021. So the board is now in the process of revoking Article 29A and 29B regulations that are no longer in use. This year, and what's currently in front of you substantively, the board is seeking to change the University of Kansas standards in Articles 29B and 29D to provide options for guaranteed admission without an ACT, something the other universities already allow for. And additionally, we are doing some cleanup to the 2020 amendments and updating internal references either by amending Article 29A and 29B regulations or by creating new Article 29C and 29D regulations and revoking their predecessors in Article 29A and 29B. That's probably as clear as mud. I'm so sorry. The other thing I tried to do to help with just to give a visual is there should be a chart, somewhat like this, at your place. And what this is off of our website, and we tried to make it a little easier for students and high school counselors. So if you look down the chart, you see the regs in the number order. So sometimes there's an A and a B right next to each other, but it'll say which one's in effect for which cohort, and then you go to the next one. And they're in number order so that you can read them down sequentially instead of going back and forth between articles, and then you can link in as you go.
Is there any way someone could make a copy of that?
I am sorry. Did this not get to you? Okay, that's my bad.
It's all new to me.
Okay, I'm sorry about that. I can certainly provide a copy.
That would be
Thank you, Jill.
really helpful when we're talking about things.
And I have an extra one, but I only have one extra one. I apologize.
okay, we'll
I
wait.
intended for you all to have that.
I have a general question before
Okay.
you finish. I'm looking at this and it sounds like we're making everything a little easier to get into schools. Am I correct in that belief?
The last couple of years, the changes that have been made would allow more eligibility for more students.
All right, and as Vice Chair of Higher Education Budget, my question is, you're already having problems with students with remedial classes because they're not being taught correctly K through 12. So are we lowering the standards? And Senator Faust-Cadeau said something about her mother, and I'd love to write that comment down that you made before because I like it. But my dad said, well, if you set the bar low, that's all you're going to get.
Okay.
And so I'm a little concerned that we keep doing this. I want kids educated. I want them all to succeed. I want good tax-paying Kansans, believe me. But when we keep lowering things, who are we letting off the hook here? Are we letting K through 12 get away with things, or?
Right. So what I would say, what was done last year was to remove the curriculum, the board. Okay, back up even further.
I know you could
Originally,
take your time. I don't want you to get yourself in trouble.
well, yeah, I'm gonna need some water somewhere along the way. Originally, there were options, and primarily three. You could either have the Board of Regents curriculum, or you could have a 21 ACT, or you could have a certain GPA. At one point, and I think it was in 2009, the board decided that we should require the curriculum even, and in addition to one of the other of those other two what used to be options. So for a period of time, we were requiring the curriculum, which led to a lot of issues, because when you have students coming in from other states, when you have, of course, the different curriculum across the state, trying to make sure that curriculum for all of the districts in this state were courses that were approved and could be used in the Board of Regents qualified admissions curriculum, or that we weren't keeping an out-of-state, a non-resident student from coming in because they didn't have the right speech class or something like that. it became difficult, and pretty soon we were, it was like the exceptions were almost swallowing up the rule when it came to the qualified admissions curriculum. And they continue to learn what's best in terms of determining a student's ability to succeed in college. Is it their GPA? Is it their ACT? Is it the curriculum they took? And I think that it's been determined, people who are more on academic affairs than I am can correct me if I'm wrong, but I think it's been determined that it's still a good idea to have certain curriculum before you come to college to help you succeed. And we're still recommending that students have that curriculum. We're just not requiring it anymore. So is that lowering the standard? I'm not sure. It's going back to where we were in a way, a few years prior to that. We've actually increased the GPA requirement for K-State and KU. We've left it the same, I think, as it's been, maybe increased it a little bit. Now I can't remember, for the other universities. So not everything is getting easier. Some of it's getting harder. This particular set of regulations is not harder. It's providing a test-free option for KU, which the other universities already have. And they determined that that was necessary and will be helpful potentially going forward, because during COVID, they didn't administer the ACT test. So we had students who were unable to meet the requirement, because the requirement at KU is you had to have an ACT and a certain GPA, or I think that was it, an ACT and a certain GPA. And without the ACT, you couldn't have the guaranteed admission. You had to roll over into the committee, and then the committee would determine, based on all of your portfolio, whether you were eligible, going to be successful, et cetera. So anyway, they wanted a test-free option like the others had, just in case that happens again, and we can't rely on ACT. So they are just divorcing sort of the ACT requirement from the other requirements. And the other thing that KU is doing that I think makes it so that more students are eligible is that they are eliminating the deadline for first-time freshmen. They had a deadline of February 1st, I think, that if you applied before February 1st, it was the guaranteed admission. If you met ABC requirements, you were in. If you applied after February 1st, it went to the committee, and you weren't necessarily in, even if you met those requirements. They're eliminating that deadline so that now everybody has, regardless when you apply, you have the guaranteed admission options available to you. So that's a long way of answering your question. I'm not sure we're necessarily decreasing the things that currently are believed to indicate what your chances of success in college are going to be. I just think they're changing kind of with the times.
All right. Senator Warren, you had a question.
Thank you, Madam Chair, and I apologize if I have missed this testimony, but and I appreciate you coming to testify in front of committee today. Does the Board of Regents have evidence that historically students with a 21 or greater ACT and a 2.0 cumulative high school GPA have success in college and they graduate successfully? Or what evidence do you have that that is a group of students who will have success?
Can I call on my?
Yes, you may phone a friend.
Thank you. Phone a friend. Somebody come to the mic. I know we do. I can't, I'm not as familiar with it as others in the room.
And if you would just introduce yourself
when you come up to the microphone so that we know who we're talking to?
Yeah,
Please.
I'm Daniel Archer, Vice President of Academic Affairs at the Kansas Board of Regents.
All right, Daniel, thank you.
And so I think one of the big things in terms of shifts that you've seen in higher education historically, particularly in the 90s, there was a big trend nationally to put all your eggs in one basket and to look solely at an ACT score. As time has gone on, there have been study after study that has shown that a high school GPA is actually a better predictor. ACT is still a good predictor. It's not that it's a bad one, but a high school GPA is a little bit more indicative of the student's heart and work ethic. And so there's plenty of data to show that a 21 ACT, you're going to be college ready in those core subjects, and then a 325 was something that we looked at a couple of years ago with K-State in particular. I can speak about that. And we identified a 325 as the GPA threshold there based on looking at the high school GPA in relation to first year to second year retention in college, because that is one of the biggest indicators by which universities are judged upon is the first year to second year retention. And they saw that I think it was like a 12 percentage point difference. It was higher with a 325 GPA versus a 3.0. So that's kind of how we landed on those areas.
Senator, does that answer your question?
Well, I'm still concerned, Madam Chair, and to follow up on your comments that, are we just lowering the standards, making it easier so that we have more students who can feed the cost of the administrators at our universities and colleges without the success that these students are likely to have? Historically, colleges and universities have had standards to be admitted because they are an indicator of potential success for the student. And to, I would say, change the standards in these ways is very concerning. I think if you go with the second standard, you have there a minimum of 3.25 cumulative high school GPA, and we don't have some objective standard that's the same across the board, such as the ACT, that presents difficulties all its own. And I'm concerned that we're getting rid of all objective criteria in looking at admissions for our colleges and universities. And I don't know, have there been any studies about what happens when you eliminate the ACT altogether and all objective standards? Because the ACT is the same for everybody who takes it.
The high school GPA and studies looking at rural populations, urban populations, East Coast, West Coast, Midwest, whatever the case may be, has definitely shown that the high school GPA is a better predictor of success. So that's definitely been shown time and time again. I would say that, there's just been a shift here lately. The access is definitely emphasized. And I think the other thing is that we've just fundamentally changed in the ways in which, our universities are doing business, in the sense that we have a lot of analytic tools now that are available sort of in a toolbox, to go back with that reference, that can help identify areas of struggle when the student comes in. They can look at a high school transcript. They can look at other things that they talk to the student about their study habits. They can identify weaknesses on the forefront, and they can identify the students who are going to need interventions before they start struggling, because the old system was, well, we kind of wait till they would fail a course and then we try to intervene, and it was too late. But if we can identify problem areas and we can provide that support and be proactive rather than reactive, we have a chance to increase access, but also increase success.
Isn't part of being proactive is to have the standard of the ACT, which is a standard measure that is being proactive? That if you don't meet the minimum of the ACT requirement, that right there is a proactive way to look at which students are likely to have success or not. And your comment about running the universities and colleges like a business, again, is it just to feed the administration at the colleges and universities and not really for the students there? I think I've seen some studies that administrations, I don't know if necessarily in Kansas, but the number of administrators has grown in the last couple of years, decades, far in excess of the number of students who are there. So I'm just concerned about the intent of changing this. Is it just to grow the student population, or again, to feed the business requirements of the university? And I would also want to know the student debt that students with a 2.0 GPA come out of our colleges and universities. So those are my comments and my concerns. And do we have any studies on what the student debt is for a student who entered with a 2.0 cumulative high school GPA?
Not anything I can cite or quote. I mean, I'm not.
Madam Chair, can we request KLRD get that information for us, and quite frankly, for
Absolutely.
a 3.25 cumulative high school GPA? Are we just creating student debt for these students with not as great chance of success based on their ACT score and their cumulative GPA?
Absolutely, we can request that. And I think I'm going to sneeze. That's why I keep exactly. So forgive me if I suddenly sneeze right into the microphone, but I think that's a reasonable request. Senator Faust-Godot.
Thank you, Madam Chair. And I just might say that this has been one of the most exciting joint Rules and Regs Committee meetings ever.
Ever, yeah.
So thank you. And I don't know, I'm not agreeing or disagreeing with anyone. However, I'd like to ask, you know, because I have two daughters who've both have graduated college, and they have a lot of friends. So I am like an honorary millennial. Yes. And so I try to stay updated on everything that's going on. However, a lot of the meetings that I've attended lately, we've talked about evidence-based, you know, with our Senate Bill 367, where we put money into communities to help keep young people out of the jail system, correctional facilities. And so performance-based. So would you say that your previous comment is more geared when you say go on the GPA? I know a lot of people, a lot of my daughter's friends. Well, let's use both of my daughters. One scored high on the ACT test, and the other one just barely made it. One daughter does very well, or did very well testing, but the other one would just cram up. She, you know, but her schoolwork all along was consistent and made sense when she didn't have that pressure of testing. Some test well and some don't. Is that part of your evidence to show? And then, Madam Chair, I'd ask this gentleman if you can provide the committee with proof of those that wanted to go on to higher education but didn't pass that test, therefore they were rejected. I mean, are those things I'd like to know that if you have that information, but is part of your theory and your recommendation because of, just use my two daughters, one tested well and one didn't, but they both, anyway, they both eventually graduated from Kansas colleges, but thank you, Madam Chair.
Oh, I definitely think you provided a very good example, because there are many students who have a lot of grit, that have a lot of ability, that work really hard, that can, they may have some deficiencies, but their work ethic can get them past that. And so I think this provides a window, rather than relying on one test on one day, looking at a GPA as 4 years. It's a 4-year body of work. It's far more encompassing and covers, you know, multiple subjects. So it's also effective to look at how they perform in certain high school courses. And that's another thing that, you know, we're at a point now where higher education is really starting to kind of reform, and we're getting away from just solely relying on standardized testing, just looking even at course placement and whether or not someone's eligible for college algebra or eligible for English composition. Again, I go back to the high school GPA, and grades in certain high school courses have been a better predictor of how they perform in those versus the ACT.
Oh, I can guarantee that my grade point average in Spanish was far worse than my grade point average on everything else. Does anyone else have a question or comment? Representative Wagner.
Yes, thank you, Madam Chairman. I do, when you say that people with lower GPAs or with lower test scores can have equal success, I mean, what is the definition of success? Is that just graduation rates, or what are you referencing?
I would say, you know, a couple of different things. I would say grades and college gateway courses, so looking at things that would be early success in terms of whether they pass college algebra, whether they pass English composition. I would say first year to second year retention, that's a big indicator, whether or not they return for year number 2. If they start one fall and subsequently return the next fall, that's a big indicator, and then graduation rates. So it's a number of different parameters that show that.
If I may, the only college, and I remember this, I'm a KU graduate, that you actually, it used to be like open admission for anybody. If you graduated from high school in Kansas, you would be accepted in any of the Regent universities, correct? That was the old standard.
I believe, I've only been here 2 years, but I believe that is correct.
Okay, and so then the reform was, for the University of Kansas at least, you would have a certain higher standard to be met. And so this is basically, it didn't affect the other colleges, and so this is going, sort of heading more back in the direction of just open admissions. If you have am I reading this wrong?
Well, there's still thresholds. I mean, I think before it really truly was open admission, right? There wasn't really any threshold you had to meet to be admissible, whereas now you still do. It's just not as restrictive.
I believe you were supposed to be living and breathing to get in before.
Well, yes, before the statute, before the qualified admission statute was passed, which was, I don't know, I can't remember the year. I have it in my notes somewhere, but I can't remember the year. It was open admission for all the state universities. Then the legislature passed the statute, which set the original qualifications. And the original qualifications are what had the 3 options. You either had a 21 ACT, or you had a certain GPA, or you were a certain rank in your class, I think were the 3. Over time, those have been changed because the legislature gave the Board of Regents the authority to set standards that were different than what's in the statute. The board did that originally for all of the institutions. I can't even remember. Sorry, I tried to write the notes down so that I could have it fresh in my mind, but they originally did different standards for all of the institutions. The KU ones were adopted like 1 year later, which were ratcheted up a little bit higher than what the other 5 were. So we had that happen. Then we had, and that I think is when we required the curriculum. So it was no longer one of 3 options. You had to have the K-Board curriculum in order to be admitted, along with the GPA, ACT. So that was put into place. That was then what was taken out last year. The requirement for curriculum was taken out for all of them, all 6 of them, because there were issues with requiring the curriculum. And it was, over time shown that, maybe that wasn't the best indicator of success, that they have a prescribed, very prescribed curriculum. I mean, it was detailed about what you had to have coming out of high school. I don't know if that answers your question or not. It's still a qualified admissions. You can't just, not everybody who applies is going to get in. You have to have either a certain ACT or a certain GPA, or both at KU in some instances.
If I can ask, if I'm not mistaken, in Big 12 institutions, I mean, college enrollment has been dropping recently in the last couple of years. Is this designed to counteract that, to be able to increase the size of your freshman class?
I don't think so. I think, as we've said, the test optional change this year for KU, it puts them in the same boat as all of the other state universities in Kansas in terms of not being so reliant on that one test that when they aren't giving the test, I mean, this is a COVID thing. I mean, this happened over the COVID year. The test wasn't administered for a period of time. Students weren't able to meet the curriculum, the test requirement because they couldn't take the test.
But this is a permanent change you're trying to make.
It is.
Not just like a 1 year because of COVID. You're actually permanently
It
looking to
is.
change.
It's a reaction to what happened during the COVID year.
All right, Senator Tyson.
Thank you, Madam Chair. And if I may, the University of Kansas came to us and asked to set those standards higher. They wanted to be an elite university in Kansas. So I find it somewhat conflicting that they're coming back to us today asking to lower those standards. To me, this is all boiling it down to, well, you can see what it's adding up to. And it's disappointing that our universities are putting money and dollar signs above actual students' education. And I think there is some concern as to, I've heard from educators, they don't want to be named out, but they are extremely upset at the remedial classes that have to be taught as a result of students at our universities and colleges. And they are upset because as a taxpayer, these students are able to take these classes 3 and 4 times or even more. And it's paid through for grants or scholarships, and us, the taxpayers, get to pick up that tab. I can understand taking it once, maybe twice, but 3 and 4 times. And these instructors will tell you that these students have no care for passing that class other than they're getting to play sports or whatever they're doing. So, Madam Chair, I am disappointed that these rules and regs are before us today, and I don't understand, even on the first page, it says that they are going to review it, but they already have that process into review. So, thank you, Madam Chair.
Thank you, Senator. Representative Sutton, please.
Thank you, Madam Chair. I wasn't going to wade into this at all, but something that you said kind of begged a question. When you mentioned the core curriculum, the Board of Regents curriculum, there were difficulties in providing that curriculum. Could you expand on that a little bit?
Sure.
Thank you.
For instance, with a non-resident student whose, different states have different high school curriculums, and maybe that student had everything they needed but this one course that was required, and then they either had to go back and take it during the summer or they just weren't going to be eligible for admission. That we tried to work around that with some alternative qualifications so that we didn't have situations where it just really didn't make sense to not admit a student because they didn't have that one thing. We had similar issues in Kansas because the different districts have different curriculum, and so they would every year contact us and say, can we add this course to the list, so that our students can take this course and not be harmed by not, having an equivalent course that's prescribed by the curriculum. And so every year we were adding to the list or changing the list or trying to accommodate so that we weren't inappropriately not admitting students. And so that's some of the administrative difficulty. I don't think that was the entire reason for doing away with the curriculum, but that was some of the problems that we were having with it being a requirement. Whereas previously, we can have the curriculum, we can encourage students to take it. We still have the Kansas Scholars curriculum, so you still have the benefit of taking the curriculum by getting a scholarship or being named a Kansas Scholar. So it's still encouraged that you take that curriculum. It's just not going to be required anymore. So, and it's not. Starting in summer 2021, we've no longer required it. That was done last year. so that we're not putting barriers that aren't helpful in the way of students being eligible for admission to the state universities. And I did want to point out, I'm not sure I made it clear, on the KU standards, if you don't have the ACT, you have to have a higher GPA. So it's not the 2.0 GPA no matter what. It's a higher GPA if you don't have the 21 ACT. So the 21 ACT can help you balance out for students who don't have that higher GPA, but if you aren't going to go with an ACT, then you do have to have it higher. And it's a 3.25, which is the same as K-State's admissions standard right now.
All right. First off, I also wanted to apologize. I went out to our vending machine and it's open and empty. There is no water. I tried.
Thank you.
It just wasn't going to happen that way.
I appreciate that.
I understand when you say students from out of state. Okay, I get that. They would have no access to what our Board of Regents requires in our state. That makes sense to me. It does cause me some concern that districts within our state weren't able to keep up with the curriculum. What sort of issues did you run into?
Oh, gosh. First of all, when I say that the standards, well, it's not the standards, but the course content requirements of some of these regulations that we're asking to be revoked now, they're no longer being used, very prescriptive. I mean, so not only did we say you have to have science, you have to have English, you have to have speech, you have to have social science, what all the categories. Not only were we prescribing the categories, we were prescribing what you had to teach within each one of those. And some districts aren't able to get all of the science teachers they would like to be able to have. Or maybe the higher level math courses they would like to be able to have. I mean, some districts are unable to get teachers that are qualified to teach some of those courses. I'm speaking in generalities because I can't give you a specific example. I'm not going to be able to tell you which districts and what courses and that kind of thing. But there were things like that. And so part of the problem was the specificity with which we were detailing what you had to teach in those courses. I don't know that I can give you any additional, and the folks behind me are relatively new. They were here when we were doing all of that, so.
And my concern is, I get it that we're sending a lot of kids to college who aren't prepared for it. And we've gone on about the remedial classes and that sort of thing that are necessary to get them up to speed. And that causes me concern for the students themselves. But when I hear that there are districts that are unable to teach the things that would get them up to speed, now suddenly the responsibility is shifted from the student to our K-12 system, and that causes me even more concern. But this is not the area in which we'll be fighting that battle. So with that, I thank you for your time, and I thank you, Madam Chair.
Just, if I may.
Yes, you may.
So the board has a strategic plan. And the strategic plan includes 3 pillars, and one of the pillars has to do with access, and they are as concerned as anybody, maybe more so, with balancing access with success. So they are very interested in all of that. They don't want to artificially keep students out of the state universities who really will be fine and do well. They also don't want to admit students who aren't going to do well. They are concerned about the student debt load. They are concerned about all of those various issues. And so they're trying to balance making sure that students who can and will do well have that opportunity with not for business purposes or whatever, just getting students in there to, to put widgets in that's not what their goal is. In their plan is to try to balance that out with 6 state universities, and they're all different, but some consistency between them. Anyway, it's not that they're trying to make this easier just so we get more students in at the risk of them not succeeding and not being able to pay for it. That's not where they're trying to go here. So suggestions for how we might do better at that are certainly welcome.
Okay, does anyone else have a question or comment? I will just add, the only thing, and this does not have to do with this, but I'm concerned too that the Board of Regents is willing to take money for more remedial classes. It's a big problem for me, as well as that they don't have they're trying to make things uniform for all Kansas students. But I can think in particular of my daughter who took nutrition at K-State, went back to get a second bachelor's degree, and had to retake it at another Regents school because they weren't the same. And I thought, okay, we're talking about Kansas Regents universities. There are a lot of things that are concerning for me, not only for higher ed, but for K through 12, that I think that we are just allowing things to go along and not ask for more.
Trying to work on that curriculum that's the same across the state for no matter whether you're a 2-year institution or a 4-year institution, that if you take English 101, it means it contains these elements and it's going to transfer from one institution to the other for the same level of course. Been working on that. It's kind of a big ship to turn.
Yes.
But,
I noticed that the higher ed does move kind of at a slower speed.
Yes.
Maybe not as slow as the legislature. Oh. All right, thank you all very much for being here.
Thank you so
Sorry to
much.
put you on the hot seat, and you brought up a very, an issue too with the ability to get something to drink in this building. I've discovered for quite a while, you can't find a water fountain, you can't find, and it is a problem, and I would like to have someone address that as well, and in this legislature.
So I looked at the Curtis building before crossing the street. They did have the vending machine that did have water in it, but I did not have the correct change. So, yeah. Oh,
yes,
good to know. Get some out the way. Okay, gotcha.
So and also when we send out information, we should tell people, bring hydration with you, like staff usually does. Thank you very much for being here. We appreciate it.
Madam Chair, appreciate you.
All right, we're down to discussion and comments on proposed rules and regulations. And I know that we've already said quite a bit. Does staff want us to go over anything that we have missed? I know that we want more information about the KBI. I believe that was from Senator Faust-Godot. I got to go through my list here. The Department of Labor. Please feel free to join if anybody wants to add anything to this list that they not pass these rules and regs that are more legislation than not. Maybe a thank you to the Secretary of State's office and an encouragement to all other departments to eliminate outdated rules and not replace them with a new one. So any new rule or reg that they decide on, they have to take one out. That's in my wheelhouse there. Is there anything else information that anyone wanted? Senator Tyson.
Thank you, Madam Chair. On the last rules and regs on the Regents, if you look at the dates stamped by the Division of Budget and the Division of Administration, it was the same on, I guess I'm wondering their process. They don't get all the rules and regs at the same time, or they do? Because two of them were stamped on the 30th by both the budget and administration. And then if you go to the next, no, it was the 30th too. But then the fourth one is the 30th and then July 2nd. So they have different dates on them. They don't go through the process at the same time. And my question would be, I guess, well, yeah, that would be it, that they have different, they flow through the process and they just come to us as a packet.
I think that's reasonable to ask. I would also,
Advisors or research might be able to answer.
oh,
this, if I may.
yes.
Yeah. Thank you, Madam Chair. It would not be uncommon for some rules and regs to flow through the process without any extra comments or changes suggested by Department of Administration or the Attorney General's office. So those would just continue on through the process, and then some that would maybe be held up and require changes requested by either D of A or the AG's office will get those stamps later in the process, and then they have to go back through. And so some, it wouldn't be uncommon for them to have different dates. And then I'm guessing the agency wanted them all presented as one for just convenience sake for the
I
committee.
guess my question is more on, I've never seen them with the same date from the two different, from the budget to the administration. I thought it was the entire packet, but it's just 3 of them, so they could probably, 4 of them.
All right. I would also ask the revisor or research to look into our departments and organizations to be putting their hearing dates onto our website of our committee, where it says that so that more people can see when they're doing their own hearings. Does that make sense? All right, so if I'm not picking on the Board of Regents, they decide to have hearings about their curriculum, they send information to the legislature so that someone, a Kansan would like to know, when is the Board of Regents going to meet to hear this and have more public hearings, that those dates be noted on our committee website. Is there, I mean, this, you know, when you pop up with that, you'd see a list. I'm not asking for a lot of information. I'm just asking that we do as much as we can to let, we have to find a better way to let Kansans know what's going on so that they realize.
Jill Shelley with Legislative Research. While it's not one that probably the average Kansan knows to go to, the Secretary of State's office does have a separate list of anything that has been noticed for hearing.
Okay.
So it is added to that list when the notice of hearing is published, and it stays on the list until that hearing has been held. And it includes the hearing date and the text of the.
Can that link be put on our website? Of the legislature website, just so that people can get on the main, maybe on the main page. I'm not a computer expert. I'm just thinking if we can make things easier for people to go to and discover information, that they could do it.
I believe we could put it on the KLRD committee website. As to additional legislative websites, that's outside of my purview.
All right. Is there anything else from the committee? I see someone that's ready to go. So thank you, everyone, for being here. We appreciate it, and drive safely home. I call this meeting adjourned.